right, the time is 11 a.m. I will call the June 23rd, 2021 meeting, task force meeting for rule rewriting for the Arizona Board of Pharmacy to order. My name is Lori Walmsley. Dr. Gandhi, can you start by taking attendance, please?
Of course, thank you, Madam Chair. Ms. Walmsley?
Here.
Ms. Nair?
Here.
Mr. Dang? Mr. Pond? I'll reach out to those two. Emily?
Here.
Ms. Fine?
Here.
Karen? Nishi? Karen? Thought I had seen her. She's on mute.
Present. I'm here.
All right. Mark? Rosen?
Here.
Roger, we heard Roger.
Here.
Sandy?
Here.
And Michelle Almer.
Here.
Perfect. I'll reach out to Kevin and Mr. Pond here.
Thank you. Dr. Gandhi, do we want to take declarations of conflicts of interest? Does anybody have
Certainly.
any to disclose for today?
My name is Karen Nishi. I work for BD Systems and we own CareFusion Automation and Cubex Automation.
Thank you, Ms. Nishi. Dr. Gandhi, do you want to go ahead and direct us to where we'd like to go next?
Certainly. I think at one of our task force meeting, we had discussed that one of the priorities to discuss would be legislative bills that will be effective in the near future. And the one that I think we need to discuss is 1087. I did incorporate a grid in your packet outlining what was in the bill itself to talk about non-disciplinary civil penalty, as we're going to have to work that into the regulation here in the near future to be compliant with our bill. That would be a good place to start, Madam Chair.
Thank you. So task force members, just to direct you where it is, it's page, the grid that Dr. Gandhi is referring to, I believe, is on page 73 of the packet. Do we want to display that on the screen, Cam, or how do we want to handle that?
Yeah, I can certainly do that, Madam Chair. Let me pull it up here. Are you able to see it, Madam Chair?
Yes, thank you. Appreciate that. So task force members, thoughts on this as a starting point?
Lori, could we just, I think I understand what it is, but sort of just explain what the grid is to everybody. I know there's people watching also, how it's supposed to work and what we're thinking.
Yeah, Dr. Gandhi, do you want to take that or would you like me to?
If you'd like to run with it, then I can fill in if I need to, Madam Chair.
Okay, thank you. So Senate Bill 1087 allows the board to issue non-disciplinary civil penalties before those would have been considered disciplinary action. So the purpose of this is to establish what the board may use as sort of a guideline, not in an absolute manner, but in a guideline how we would want to handle these matters that are brought forward to us. As an opportunity to address the non-compliance with this particular thing. So these would be non-disciplinary penalties, if you will. And my understanding here, Dr. Gandhi, is we're looking to see if there are anything else that potentially should be considered within this grid, if there are things that perhaps shouldn't be considered as part of the grid and what the penalty would be, then we would make a recommendation for the full board to potentially look to adopt this at a meeting. Is there anything I'm forgetting?
No, you hit the nail on the head. I did categorize it into 3 buckets here. The first is, according to the 1087 bill, there's a one-time violation and almost kind of like a free pass. You get a slap on the hand. The next time it would move to a complaint process. And then there's a second component where you're allowed to have 2 strikes, and then a 3rd strike would have to go before the board. And those are specifically identified in the bill. And then I added an additional component where I felt may be up for consideration, as it's more administrative and not a threat to the public, or may not be a threat to the public, for your consideration. You can certainly add on additional items for the full board to review. But in addition, if anybody has thoughts on what the appropriate civil penalty would be for these infractions, that could be presented to the full board as well for consideration. I felt that we have the appropriate parties on this task force meeting to discuss that, who represent different facets of the business. And maybe we can capture what would be a fair outcome. Again, this is just another option that the board is given, as we've never had this option historically before.
So I have a couple of questions on it, and I don't want to monopolize, so I'll just ask a couple of questions. We'll go through with it. On the first one, which says failure to complete CE, it says already have grid. Does that mean we already have a grid for the penalties?
No, well, we have for the actual discipline, we have a grid for it. It's $100 per CE. For technicians, it's a different value. I don't know if you want to adopt the same guidance, or if you guys want to consider something different.
Okay, so I just want to understand what that one is. And what is the range of civil penalties pursuant to the statute that we may impose, that ultimately the board has to decide if in the rules they want to do?
I believe the civil penalty is still maxed out at $1,000 per violation.
Okay. And then my last question, just on these ones, on 5 and 6 under the non-disciplinary civil penalty not to exceed 2 consecutively, failure to notify assignment of PIC and a DR, that is both for the pharmacist and for the facility?
That would be for you guys to make a recommendation. It
Okay.
was generically written in the bill, so it's not specific to a permit holder or licensee.
I have a question where it says non-disciplinary not to exceed 3. The way that I'm reading the bill, this is page 46 in the packet. It says with 3 or more violations being presented to the board as a complaint, and then it has a list in statute, and well, in this new bill, and then it said, the board can put additional things that fall into this category.
Right.
But up here it says 2.
Not to exceed 2. So as soon as it hits the 3rd one, it's kind of like a 3 strikes you're out kind of thing. So you're given a pass on 2. You're interpreting it differently, Kelly?
Well, it says with 3 or more, so they could have, I guess, 3 or more. Okay, it would be presented to the board as a complaint.
Yeah, so the way that I read that, the board could either choose to issue a non-disciplinary civil penalty if it wasn't repeat violations up to the 3rd violation. We can potentially give that to the discretion of the executive director. If not, it would be presented as a complaint. Okay. But I assume that potentially, Cam, these would fall on your actions that you take as a recommendation for ratification at the board meetings, like you do for the dismissals. Is that how you envision this looking in the future?
Correct. Yeah.
Is there any time period for those when you hit the 3? Is it like lifetime, or is it over 5 years, or?
There's another bill that says 5 years. I believe Mr. Bozen introduced that one. That once the terms of the conditions are met, discipline is viewable, still up for public record. It never disappears from our agency, but it will not be viewable online. And 5 years would be the expiration date. But this is non-disciplinary though, Roger. It's not supposed to be shared with the National Practitioners Database. It's more internal.
No, I understand that. I'm just trying to figure out if I fail to update my contact information in 2000, 2020, and 2030, am I now subject to civil penalty?
It's, if I try to reach you twice, Roger, and I can't get a hold of you twice, that's 2 violations, right? And then a third one, for whatever reason, I have to get a hold of you again, and I just can't, that becomes a 3rd violation, going to go before the board. And yeah, it probably would end up to be a disciplinary action at that point. But then that's the board's discretion still.
So Cam, are you talking about just a staff's attempt to reach a licensee or a permit holder that is unsuccessful? Or
I think that's the only way we'll know if someone has updated their contact information or not. Today, I don't know how many records are accurate, not accurate. We don't cold call anybody just to make sure they've updated their information, but we do have challenges when we call someone on a case or investigation or something like that where we can't get a hold of them. We get return mails all the time, certified or not certified, because those folks have moved and not informed us.
When someone updates their contact info on their online profile by their own accord, like, oh, like I moved, I need to update this, do we capture the actual like move date? I have other states that do that, and I'm kind of like, sometimes it will actually like prompt a violation if I report it too late after, or is it like the honor system where you have proactively updated your contact info? As long as there's no issue with the staff getting a hold of you, it's not a problem.
I think our system is set up as an honor system. I'm sure that information is captured by our vendor if I wanted to dig deep and do a forensics analysis. But again, we're not here about, we got you. We'd just like accurate information on our website.
Okay, that's helpful.
So Cam, this is Kevin. Given the fact that communication is so important between the licensees and the board, if the licensee failed to update his or her address, can we count that as a violation? Because it's clearly stated in the law book that you have to update the board within 10 business days of where you reside. And if people are not doing that, I think it should be considered as a violation.
Today, yes, it can be.
Well, even if we make this grid, it will be a guideline. We can deviate if that's the way we want to go, but I don't know that it would be where we'd want to go for something like that.
In my opinion, I think if we are going to press the require the licensees to update their address, that will help us resolve at least 25% of all the issues that we're currently facing with.
My personal opinion is I think that this would solve a lot of that if we put in a newsletter that there are these new non-disciplinary civil penalties that can be issued. I would think that certainly licensees would be a little bit more inclined to do that. I think probably the majority of people do. But if they knew that they were going to get a fine if they didn't do it, in addition to potentially whatever other action is outstanding, I would certainly think that would be a reason for people to pay a little bit closer attention to this. Just my personal opinion.
Cam, is it your intention to put the actual grid in a rule?
No, this is just gonna offer me a guidance on how to deal with this. I'll let my rule writer figure out the proper formatting and stuff, and the verbiage. This was just put together for me for discussion today.
Because the rule or the statute, the bill says that this is all the civil penalties have to be prescribed by the board in rule.
Yeah, so we'll put it in some sort of format. I don't know if it's gonna be this grid, but it'll be identified in rules somewhere, yes.
Lori, can I ask another clarifying question?
Yeah, go ahead, Kelly.
So in reading it again, and I don't know if it's just that I'm confused or I'm misreading it. So the way that D reads, because there's number 1 and 2 below it. D is specifying when, and the board can add additional things to this list, but this is the list. The things that are deemed, not an imminent threat are subject to a non-disciplinary civil penalty. And so there's 1A and B, and then there's 2. So the way that I'm reading 2 and framing it in that context of these are non-disciplinary. So if there's 3 complaints issued because somebody hasn't updated their license or other things that are listed below, that those are non-disciplinary.
Well, we have it listed under non-disciplinary, right? On this grid.
Yes.
It's non-disciplinary unless it exceeds 2.
I don't see, that's the part, I guess, that I'm questioning. It doesn't say, to me, I'm not reading it that unless it's more than. Not to exceed 2 violations. I'm not reading it as that once you've had 3 or more violations of any of those lists, A through, however long that list is, A through F, then they could be issued that non-disciplinary civil penalty.
I think I read that as 3 or more, then it would go to the board as a complaint, then that's subject to discipline.
I guess the way that it's worded in here with the commas and everything, it's saying violations or any of the violations adopted by the board in rule, comma, with 3 or more violations being presented to the board as a complaint. But the context to that is that these are non-imminent threats and are subject to non-disciplinary civil penalties.
So
And maybe
Kelly,
it-
are you asking if you get disciplined, if you can get a civil penalty after the first, or do you only get the civil penalty after the third?
The way that the way that this reads to me in number 2 is that 3 or more of the violations that are in 2A through H could result in that non-civil or non-disciplinary civil penalty. But I think the way some are interpreting it is the other way, where you can't have 3 or more, or a complaint would be issued before the board. And I don't see, D doesn't frame it in that way. It just lists the occurrences or the items that would be considered non-disciplinary. So it could, I think it's an interpretation issue, or the way that it's worded maybe with the grammar. And I don't remember the intent behind that language. So I'd have to kind of go back and reread notes, but.
So I guess we need to figure out what is the intent. And I'm just not clear from that discussion. If someone fails to update their contact info the first time, is there a penalty or not?
There could be a non-disciplinary civil penalty, yes.
Correct.
After, the way I read it, after 3 times, it can go to the board as a complaint and subject them to discipline.
So
Third
the
and-
first, okay, the first 2 would be civil penalty. The third could be formal discipline.
Correct.
And Kelly, you're reading it different than that? I'm just trying to make sure we're all in the same place.
Yeah, we can jump to something different. I don't want to take up a lot of time. I don't read it that way, but I'm not an attorney either, so I don't, the way that I read it, it reads different to me, but.
I see both sides. I see how, I think the confusing part about 2 is it says the occurrence of any of the following with 3 or more. And that's what is technically under the things that are subject to a non-disciplinary penalty. But I also see how it can be seen the other way, where you can get up to 3. It's a very confusing sentence.
That's not how it was originally written.
Is this the final version, Cam? The final?
Yeah, it is a chaptered version.
Okay.
So leaving at least that issue, Cam, are you looking for us to theoretically give you some guidance that it should be $1 or $1,000 or some number in between for each of these?
Yeah, I think because we're gonna have to memorialize this stuff in regulation. And as we're discussing a comprehensive rules package, this is going to be law. Looks like the Senate may have passed the budget today. The House is still up for consideration. So by September or soon after, we may have to have this in place.
All right, so I'll throw out a number just for discussion. Let's suppose you put $100 for every one of these just to discuss, and then we can discuss whether it should go up or down for each one of them.
Well, we have 250 as a standard for not giving us information that we need when it's as kind of a starting point. So I don't know if we want
Okay.
that as a starting point. It's been kind of a standard.
It's the
fine,
failure to
let's start with-
notify kind of situation, right?
I think
Yeah.
6 and 7 should probably be the 250.
Okay.
I think the failure to submit a remodel and relocation probably should be higher than that.
Yeah.
Agreed.
Have we,
Okay.
oh, sorry, I'm just wondering if we recall if we've given out a penalty for that before and how
We
much it
have.
was.
We have, and I think it's been $1,000.
I think it's been 1,000.
In my eyes, I see the relocation as being potentially more severe than the remodel because the inspector doesn't know where the pharmacy is at all
Mhm.
in the second one. Food for thought.
Well, that can happen with a remodel too. They've remodeled in, kind of moved a location, I don't know.
In a suite or something.
Yeah. I don't know.
This is Mark. I hesitate giving firm numbers to any of them. I do like to give the board discretion based upon facts and circumstances. That's sort of where I've always liked to be. So for example, if you've got a big corporation, you have 200 stores in Arizona and 10 stores have all had one violation. The 11th one technically is just first one for this 11th permit holder, but there's a pattern here. And I would think the board would want to have more discretion to say, look, I get this is just this permit and you're entitled to this disciplinary civil penalty, but we're going to make it $1,000 because you seem to be here all the time, versus the mom and pop owner that's in rural Arizona who has been there for 50 years, 2 generations, and just didn't know, still deserves some sort of penalty, but maybe not as severe as the other one. And I like giving the board that discretion.
Well, this doesn't take our discretion away. It just gives us some consistency because if we don't have a grid in front of us, it seems like our first question is, what have we done in the past? And this lets us kind of have a guide of what we have done. That's my opinion.
Yeah, and I'm not a fan of the grid for that very reason. It ought not be formulaic.
Well, we definitely veer from the grid when we feel like it warrants it.
I agree with Mark. I mean, what if we were to put in there, you know, minimum amount up to a maximum of, to give the board discretion based on the circumstances to issue the civil penalty based on the facts of the case, instead of, like Mark said, being so prescriptive about what each item on the list would be.
Well, the $1,000 would be the max, right, per violation? So if you guys want to identify a minimum,
Like $100 up to 1,000.
Then there kind of isn't much of a point making a grid because we know that we can go up to 1,000.
It doesn't say that you need to make a grid in the rule, though. It just says that you need to have the non-disciplinary civil penalty shall be prescribed by board and rule and issued using a board-approved form. So the board can decide what items it wants to add to the list of things that are classified under non-disciplinary civil penalty. So you could have the list that would say all these things the board has approved in addition to what the statute reads. These cases, if they're before us, are eligible for this non-disciplinary civil penalty. And we can issue a civil penalty from $100 up to $1,000.
The way I read the bill, the amount of the civil penalty has to be in rule.
For each item, or
Yes.
can we?
Is a range a possibility as being described, Ms. Galvin?
You could say in the rule not to exceed, you know, $1,000 or not to exceed $500. But it says that the civil penalty shall be prescribed by board in rule.
So in the case of the relocation example, if we were to say a minimum civil penalty of 100 up to 1,000, would that be acceptable? Or is that too discretionary so that somebody wouldn't know what would be potentially, how they would be penalized?
Seth, I don't know if you have an opinion. My opinion is that the amount that you could or will assess needs to be in rule and not a range.
I would agree with that.
So I do have a question then about that. If we do come up with this and it's in rule, it's not just for us to use for our own benefit, how much can we vary from it? Because I do want to be able to have discretion.
I think to Jean's point, if it's not to exceed a certain amount, you have anything below that amount to deal with.
That's the good point.
I think we already have that spelled out as far as civil penalty, not to exceed $1,000 for violation. That's already in statute.
Mhm.
We could probably work with the rule writer to come up with some language that would afford the board some discretion depending on the facts of the case. And Seth and I can think about that and talk to the rule writer and staff. But the statute that appears in 1087 is pretty clear that the amount has to be prescribed in rule.
I have a question on the discretion piece, and maybe it goes back to this like confusion or like different interpretations of the bill. For anything under D2, do you have to impose a non-disciplinary fine? Or can the floor be 0?
Says may issue non-disciplinary.
Got it.
So it can
That-
still be, Emily, it can still be a letter of concern. It can still be dismissed, right? So I mean, that's still
Right.
the authority of the board. This just gives you another way out.
Option. Okay, helpful, thank you.
So for example, the dismissals, Dr. Gandhi has the ability to do prior to the board meeting. The board ratifies those decisions, or we decide to pull things off and discuss them further. I see this very much in that case. So for example, if Dr. Gandhi were to find out that, for example, maybe somebody was in the hospital and they failed to notify that of a change of address or something like that, some crazy extenuating circumstance, maybe his recommendation would be no fine in that particular case. And that would give him the discretion to say, I don't think that's appropriate. And then the board could decide if they wanted to issue the penalty or not. That's the way that I view it.
I would almost, Madam Chair, if I may, if the board eventually feels that they want to delegate the authority to me, my whole vision of this is on a form prescribed by the board, which means basically check off a box and say, hey, you're kind of in violation of this. We will put the ARSs next to failure to update contact, failure to update employment, so we can have a reference point. But to issue kind of like a speeding ticket, this checkbox I'd give it, we'll upload it into her profile. And so we have, documentation of what took place. My preference would be to have a minimum authority for me to start off at. And if it exceeds that minimum, then it's going to have to come before the board for discussion. And again, everything is a may discussion. So if I feel that this was gross negligence on somebody's part, and I'm not comfortable having this discussion with them, it's going to come before you guys.
For passion, and they stepped up to the challenge last week, and over 22,000 people with the COVID vaccine in the last 5 months. So great work. Congratulations on.
So my thought on the first two is, I personally think that at least the failure to notify of relocation should be higher than a minimum of 100. I think that could be potentially a significant issue. The remodel, I don't know, I'm on the fence. We might be able to go lower, but what if there were concerns in the pharmacy is operating and then they weren't inspected for a period of time?
Well, especially if it was compounding related, right? Sterile compounding, and they're not up to specs as far as requirements of USP. And we learned about it months later during an inspection, and they've been operating subpar for a while. That could compromise patient safety. So it can be tricky. Remodels can be tricky as well.
This is Mark. I think that's exactly my point. You may come down harder on a person who's put in a sterile facility, and someone who simply added a patient counseling area who should have done one. Gosh, that's something that you'd want some discretion with.
Yeah, correct. And that would be something that's not an administrative oversight. And that this whole intent of this section was an administrative issue. The minute it crosses the line for patient safety, it's going to have to go before the board.
So the compounding issue wouldn't necessarily go through this process.
Yeah, I agree.
Yeah.
Unless they haven't compounded a single item or something like that. But
Yeah, makes sense.
I would agree with that. So I don't know, I just threw up some numbers, minimum of 500, minimum of 500. I don't know how that would sit with you guys. I know we've had historically on a consent agreement settled at 1,000 for relocation remodel. And if they do this a second time, maybe that's the direction it could go in, a little more stricter penalty. Because this is a one strike and done deal. Next time they remodel or relocate without telling us, it comes before you guys.
No, that would be the third time, really, according to the bill. I
No,
guess unless you-
not for remodel relocation. It's only one strike.
Okay, that is called out,
Yeah.
called out in there. Okay, never mind.
Maybe minimum of 100 on the change of employment as well. Because it would be their third time of not doing that, so that would be excessive.
No, I think that's still up for question. It could be after the first time.
It'd be the first time and the second time, and then a third time will come before the board.
And the same thing with the failure to update contact information.
So just a reminder, the rule may require you, and I believe, or the statute may require you to set the exact amount. I don't believe that this minimum of $100 would fly given the statutory language.
Two would flow.
Jean, this is Kelly. Since we worked on the bill with Cam, who determines the intent of the language? Because I think part of what we were wanting is that for people to be aware of what it is so that it wasn't just arbitrary amount, but not be so prescriptive that the board doesn't have that flexibility. And so who gets to determine? I mean, if it was AZPA and the board working on the bill and we developed the bill, don't we get to decide kind of the intent behind it, or how does that play out?
The board, any state agency has a responsibility to interpret its own statutes and rules.
Okay.
And in determining the meaning of a statute, in this case, you look at the plain meaning of the wording. And if that is not clear, then you go to legislative intent and you would pull, committee minutes, legislative fact sheets, etc. But it is up to the board, any board in this circumstance, to interpret its own statutes and rules. That's not to say that that interpretation can be, can't be challenged later or clarified by a court.
But since these will be put into rule, Jean, this would also go through the normal rulemaking process. So this committee, this task force will provide recommendations to the board for the draft language that will then go through the full rulemaking process, including public stakeholder comments from a public viewability standpoint and public engagement process outside of the task force as well, correct?
That's correct.
Yeah, I don't see that you have an exemption from rulemaking in this. So that would be correct.
So Jean, do we work under the assumption that the minimum is not going to work and just come up with an amount? What is your recommendation for us at this point so that we can try and come up with something so that Cam can start to work on draft language and move it forward with the process?
I would recommend a specific amount.
Okay, thank you.
This is Mark. If we need to do a specific amount, I'd like to go back to Roger's suggestion of let's start at $100 if you want to talk about some that may be more extreme. But the legislature has determined these are violations that at least early on, if they happen one time or a couple times, do not rise to the level of discipline Therefore, it's a warning, and since the facts and circumstances can be different, you can have those who simply made an administrative error and those who might be gaming the system some way, somehow, because they keep violating the order, but they have so many permits and only ends up being one every time. That would be awful. But since it is just an administrative oversight, then make it nominal. Make it $100. Still triple digits. Still makes a statement. Still creates a public record that if it happens again, you're subject to a discipline, which could be up to $1,000. And you could even put that in the civil penalty. Hey, this is one. Next one, if it's in that category, could be subject to discipline up to $1,000 or revocation, termination. The standard language of things could go very badly for you in the future, but keep the first one nominal.
Thoughts on that suggestion?
I agree with the general statement. I wanted this more for us to have historical reference. Once it's put in law, in rule, that changes my opinion about it. I don't know if 100 makes a statement. I understand what you're saying, though, that it could be just an oversight and we wouldn't have the flexibility. It's just an automatic fine. I don't love that.
I think generally I'm okay with the idea of $100 for some of these items. I think there are some that perhaps need to be a little bit higher than that. When you talk about failure to renew a license, I have a little bit more pause on that one personally. I think that the violations around relocation, I do have a concern with that one specifically, not knowing where businesses are operating. I take concern with that, and then shipping into Arizona without a valid permit, I also have a little bit more, a little bit higher level of concern.
What is the
Just my
DR?
thoughts.
Just to clarify for me.
I'm sorry, DR?
Yeah.
Designated representative.
Okay.
So I have a question.
That's for like wholesalers, right, Cam?
Wholesalers and manufacturers, yeah.
Okay, great. That was my next question.
So I have a question. I was under the impression the purpose of this bill was in theory to give the board some flexibility to say, we're not happy, we're going to fine you, but it doesn't rise to the level of discipline rather than disciplining people. I'm concerned that when we're putting these minimums, what we're going to end up doing is taking things that previously would have been dismissed or motions or just some advisory letters. We're now going to be doing some penalties, and we're going to end up being penalizing more people. And I'm just sort of raising that as a concern that I thought this was to give more flexibility to do less formal, but not an intent to actually just send out more fines.
Yeah, I don't disagree with that.
I think Roger, this one, for instance, let me identify a few here real quick. So 8 out of the 12, Roger, just for discussion, the board has disciplined out of these in pretty much all cases. So these are moving from a permanent discipline on somebody's record to a non-disciplinary slap on a hand. So they are reducing considerably from a disciplinary perspective to a non-disciplinary.
And the others?
And the others, I mean, the contact information, unemployment, we typically have seen when we have people that have diverted, we just can't get a hold of them. Same thing with employment. So we don't run into those too often. And in today's cases, majority of them that we see move to a revocation because we can't get a hold of them anyways. Again, we're not cold calling people to make sure that they've updated their information. These are coming up through investigations and stuff like that. In an event, we make several attempts and all of a sudden they find out there's a hearing, and this happens occasionally, not too often. They say, oh, I moved, but my friend or my mother or my family member forwarded the letter to me. And I finally got it, that there's a hearing about my case or something of that nature. There's occasional situations where we end up calling the employer because we can't get a hold of them using their personal information, and they're no longer there. But then through the grapevine, they hear about that we're trying to get a hold of them. Again, these are rare occasions. They don't happen that frequently. But we're exhausting a lot of resources trying to get a hold of somebody.
Is this the right mindset where staff already has the authority to go ahead and either dismiss something and have the board approve, and or staff can even like suggest a consent agreement based on like something that's on another grid and have the board approve that, right?
Correct.
So is this just a third option? Like if we see it this way, right, where dismissal is cases where there's really no wrongdoing, someone's in the hospital, etc. Non-disciplinary is maybe you had to reach out, like you can handle it procedurally in a way, like you had to reach out 3 times or something, but then the person is like, oh, I'm so sorry, I'm fixing it now. And then bringing it to the board is the third option. So like there can be a set like price tag on these, but it's based on like a procedural limit of steps or outreach or something? Or is that too complex?
That's something we can definitely entertain, how much effort we have to put behind it before it escalates to a fine. Again, a failure to contact the contact information, change of employment. We generally have not written up a violation for those. And even if we did, just throwing this number out there, $50 for those issues, I'm okay with that as long as somebody learns their lesson. They get a small slap on the hand and we move forward with that. Those two I don't have too much heartburn over. It's just we're trying to expedite situations quicker so it's not taking up so much board time to do other things. And also not giving someone a permanent discipline on a record for the rest of their life.
I think the reason we haven't taken action, like you've mentioned, is because we're already dealing with some other issue.
Correct. And we're moving to the final step of revocation anyways, in most cases.
Yeah, something that's tied to it, that's bigger.
Correct.
So 50 sounds reasonable. And, you know, maybe after 3 attempts, then it moves to this. I like that idea, Emily.
Like just a way to handle them systematically. So if somebody accidentally does one of these things, but is immediately reachable by the board and fixes it, like that could result in a dismissal or like a letter of concern instead of going through this fine process is kind of what I'm thinking. But if it escalates beyond that, maybe it's non-disciplinary. Fine.
Again, it's something that we're gonna summarize on a grid to present to the board for acceptance anyways. So if I got a hold of somebody, didn't get a letter from us because they moved, but their phone number stayed the same. There's no hard feelings on that one from my perspective, and they can just adjust it and we'll move on with life. Again, these were just some of the administrative issues that we run into.
But
I
if
think
they
really
don't,
this is, and I think this is really trying to get at those people that we're not able to get a hold of at all, which,
Right.
and to make sure that we have some way that we can get a hold of people, because we see stuff at every single meeting where we've tried via phone, email, trying to call their employer of record to either get a statement from them
Yeah.
or address something, and you've issued subpoenas and all these things have come back and we're not able to get a hold of them at all. This isn't necessarily somebody that forgot to update one piece of their information and we were still able to get a hold of them. I think staff does a really good job in trying to reach out via all the different pieces of information we have. It's for those people that we have nothing.
Mhm.
I think Laura, you brought up a great point. Is we'll post this on our website, on a newsletter, and if they see some sort of slap on the hand, that they're going to update their record, and it might be an incentive for them to update their information as it changes.
Yeah.
In an interest of keeping it moving, I'll go back to $100 or $50 for these two and just put something in there to keep it moving.
Yeah. 50 sounds good.
I'm
for
good
those.
with that.
Okay.
Failure to complete CE, we've typically done in prior cases based on a per number of hours not completed. So somebody that it was 1 hour short would not necessarily receive the same penalty, for example, as someone that hasn't done any CE since the last renewal period. How does the group feel about that?
Mark, I can't hear you.
The group's not aware of my opinion on this one. So my apologies. I think there is an extreme difference between someone who has not done any CE or substantially no CE versus the person who is missing 1 hour or just in the opioid hours, did everything else. I mean, those are two different kinds of people. For the first offense, the first one, I'm $100, and frankly, for the second one, particularly since they had a non-disciplinary shit that they've already used up, I'm actually okay with the grid that exists for is $100 per.
Hey, Mark, you're coming up really.
Breaking up.
Your connection is
not good.
no.
But I would go $50 to $100 for the first non-disciplinary one, and then keep the grid as it is for the second one, because that deserves some discipline. They already got their one warning.
Are you saying second cycle or second CE within a cycle?
No, it's my impression the way that bill is written is if you're audited and you're short, there's for any number of hours, you get a warning, you get this non-disciplinary penalty, set it at $100, $50, whatever you want. But it's the next one where the current grid as it exists, the disciplinary grid, I'm fine with.
Is that for up to 5 CEs? Anything over 5 needs to appear before the board?
I don't like the 5 to 30. I think the way the statute is, you get audited, civil penalty. And frankly, I still like the not to exceed $1,000. If we have to pick a number, let's pick it low, because we're going to treat the person missing one person treating the same way. So let's keep it low and throw it out for the second time, which is a disciplinary event.
So does that even follow the statute though? If we're looking at it this way, so if say somebody that didn't do any of their CE for one renewal period, we're saying we would recommend a $100 fine if we were going with this logic, and then the next renewal cycle, which would be 2 years later, we would follow the grid. That would be another consecutive violation, but it wouldn't necessarily go to the board if I'm reading this in plain text. And then it would be at that point impossible for them to ever reach a third occurrence, because it would be after the 5-year period of time.
Precisely, which is why I like picking a number. I still like the not to exceed $1,000, give the board discretion, even in the non-disciplinary stuff of what to do. Still where I'm landing.
So I have a question on the CE. Even with the $100, it's $100 plus they have to make up the CE, don't they? But
Yeah.
How does that get ordered?
Yeah, they would have to do 1.5 times for the next renewal cycle. That's how it's typically been issued on a consent agreement.
Right.
Is the initial 100 for techs and for pharmacists? In the grid we have now, we have two separate prices.
It's a good point, and that's why I'm like, keep it nominal, because there are two different socioeconomic income pathways here that we're dealing with. We have some people who make a considerable amount of money and some people who are at entry level positions. And so if you got to set a number, pick it low.
Or you could separate it out and sell your complete CE pharmacists, sell your complete CE technicians or trainees.
This is Kevin. Can we go with $50 per CE for the technician and $100 per CE credit for the pharmacist?
I don't think they're talking about per CE, Kevin. We're talking about $100 initial fine, period, for the initial, and then maybe $50 for a technician for initial.
So
regardless of how many they did or didn't do.
So this is my opinion, and all of us here are well aware of the fact that CE is very important. And those of us who attended pharmacy school, we were reminded even in school that every year it is our responsibility to fulfill the CE requirement. So I know that state of Idaho, if you miss a CE credit, that would be a $100 fine. And if you miss 9 CE credits, whether it's the first time or second time or third time, that will be $900 fine. So given the fact that all of us pharmacists have been reminded in school, as well as the technicians, can we just make our job easier by saying that if you miss a CE credit, that will be a $100 fine? And irregardless of whether it's the first time, second time, or third time, if the licensee is willing to keep paying the board the fine, then we're just going to continue to fine the licensee until when he or she gets the point.
This is Mark. I want to state, particularly since this is on the record, I do not agree that continuing education is an important aspect of relicensure. There is little to no evidence that doing the simple act of checking the box and doing continuing education has anything to do with competency. For example, I could do all 30 of my CEs in oncology and never see a single oncolytic patient. Does that make me competent to take care of the patients I do take care of just because I did 30 CEs of something that was available to me? And so that is why I think the fine should be nominal. I don't think there's tremendous public policy value to doing CE.
Mhm. So Mark, this is Kevin again. With all due respect, I see where you're coming from, but it depends on the setting of where you're practicing as well. For example, in my personal career, I've always worked at hospital settings, and for clinical pharmacists, especially if you are going to specialize in cardiology unit or oncology unit, I always think it is critical for these pharmacists to fulfill their CE requirement in those particular fields. So, and I do believe that CE will help the pharmacists either gain additional knowledge or remind the pharmacist of what they have learned in school. So
let me qualify my statement. I believe it is important for pharmacists to continually educate themselves, but this hours in anything that's ACP accredited, but make sure 2 of them are opioid. If you deal with opioid prescriptions, doesn't help anything about your confidence. You could be a hospital pharmacist and work in oncology ward and do all 28 of your C's in immunizations if you wanted to, and that would check the box. And that's why I think this is an issue that relies on a person to be a professional and do the appropriate CE, but we don't require it. Therefore, I think the first offense should be nominal. Second offense after that, get more aggressive.
I think I don't want to get too far away from like the task at hand here. I think this is like healthy discussion, but CE is required in Arizona. So I think that's like,
I agree.
I mean, there's a lot of discussions emerging at the national level. I mean, there were some pretty healthy conversations about the value of CE at the NABP meeting, but I don't think that's the place for our discussion today. At the end of the day, I think your point is, Emily, that it's a requirement by law. We now have the opportunity to provide a non-disciplinary civil penalty for this, which should be a benefit to our licensees and still be able to send a message to individuals that are not complying. We just need to come up with a way forward with this, I think is where we're at right now.
Mm-hmm.
Well said. That's what I was going for.
I'm personally supportive of one fine, regardless of the type of license that you have. I think we're making some assumptions here that like all pharmacists are currently employed in pharmacy. Some of them are just maintaining their license. Like it may be inappropriate to assume that all pharmacists are making like some type of salary. So I think that's where my mindset is at. And I think it also just keeps it easier to do one fine regardless on a lower level. So the 50 or 100, something like that.
Jean, would this be okay, legally speaking, if we were to delineate this in the rules this way?
I would think so, yes, but that's up to you. There's a kind of a rational basis for this distinction that at least I'm hearing articulated by one or more of the members. And that rationale can be explained, as we move through the rule process.
Thank you. Are we all good with this one? All right, hearing no comments. How do we feel about number 4, failure to notify the assignment of the PIC at $100? Is everybody okay with that?
Seems reasonable.
And the designated representative at $100.
Feel the same.
Is this for the permit?
Wholesaler, right?
For
Uh,
these two, for the
permit
pharmacy
holders?
permit? Yeah.
I would say yes. I don't know. What's,
Actually, aren't these potentially against both the individual and the permit?
I kind of tend to agree with Roger there.
Well, the designated representative is not a licensed individual, so it'd be really difficult for us to put that against the DR.
But
It's a ticket.
ultimately, the permit holder can't update the PIC's profile. They can update the facilities permit, but the PIC still has some work that they have to do too, to be in compliance.
That makes sense.
Yeah, there are two components in our database. So the permittee would have to update their information, and a licensee information would have to be updated. DR, they don't have a profile to update. So it'd have to go against the permit.
Is everybody okay with that?
so it automatically goes to both, just to clarify in 4. Or line 10.
If they both missed it,
Gotcha. Whoever it applies to. Okay.
whoever missed it, I think, is the distinction.
Okay, number 6, failure to notify of a new criminal charge, arrest, or conviction. We've typically done the $250 disciplinary penalty. I would be in support of keeping that the same. Any additional thoughts there or opposing opinions? It is significantly higher than the others.
Yeah, but it's criminal issues. I think that's reasonable. And the same thing with the next one on discipline. I think those are more material than your addresses and things like that.
Yeah, I agree. And we've had it that way for quite a while. I like sticking with that.
Okay, failure to renew a license. So typically we have done a civil penalty on the individual and I believe the permit holder when there has been a failure to renew and people have worked. It has been $100 per day for the pharmacist, up to $1,000, and $50 per day for the technician, up to $500. Thoughts on that? If we want to keep it the same, is there a differing amount that would be suggested here?
So Lori, I'm in agreement with your concept. I just think we probably need to have an 8 or an 8A because I think it's different. One is failure to renew for the individual. The other one is failure to allow a pharmacist or a tech to work when not licensed for the permits.
And there also is, just to remind the folks, there also is a built-in late payment penalty as well. So there, regardless of what you do, there's already a financial implication when you renew late.
I see those separately as taking care of your license and working without a license is 2 separate things.
Or allowing someone to work without a license.
Right.
Right. So it's definitely like, it's not actually a violation if somebody just doesn't renew their license but isn't working. Correct?
Correct.
True.
So the violation is actually working when you haven't renewed.
Correct.
Yes.
So we should probably clarify that language a little bit.
We have done kind of like CE or something for the PIC sometimes too. I don't know if that's something we want to address here. I have a question about failure, the CE, sorry to go backwards, but when it says that we would follow the grid after the repeat, our grid has it as a civil penalty, not as a disciplinary civil penalty. So is that something that maybe we should discuss with the board if we want to go forward doing the grid as is, or if we would consider it as a non-disciplinary civil penalty when it gets to the point where we use the grid. And that might just be a discussion for the board to have, but just a question that popped into my mind.
I think the intent for the second violation would be to follow the grid from a monetary perspective, not the disciplinary perspective.
Okay.
They'll still be non-disciplinary, but follow the grid as far as the civil penalty goes.
And this would not apply to board ordered CE either, would it?
No,
So somebody that we issued board ordered CE for some sort of non-compliance or an error or something like that, and they didn't comply, that would be handled separately because that would be failure to comply with a board order, right?
correct. Yep.
Okay.
Okay.
But this would make it literally impossible for somebody to ever get disciplined for not completing CE based on the timeline.
So Roger, to your point, I can make it 8A and 8B if you'd like.
Well, I just think it's, if we can change the word from renewal or working, but I just think it's, one is allowing people to work, the other is working.
Mm-hmm.
I agree with you, Roger.
Yeah, this one's a facts and circumstances. I can see an individual simply forgetting and just, and that's not excusable, but they could forget, and that's a reasonable human error. But for someone who's responsible for making sure an entire organization is licensed and everybody's paid up on time, that's a different and a more profound responsibility, and one that you would expect more care and attention to, because that's why you chose to be a PIC or a permit holder. And so I would be supportive of a $50 penalty just for the one who just forgot but renewed right away and also paid the late fee, and maybe $100 or $250 for the organization that didn't do a good job making sure that their roster and licensed people weren't given reminders and were allowed to continue to be on shift without a valid license.
I agree with you. But I also think if I just told you I'm going to work without a license, that would be concerning to you. And someone is doing that.
But you didn't work without a license consciously. You forgot about it.
Right.
I wake up in a cold sweat every night. I have 27 different licenses.
I can't imagine.
And I'm PIC in some foreign states for my moonlighting job. And I wake up in a cold sweat of, oh my gosh, did I do Tennessee? Did I do Kentucky? I had every intention to. I've got this grid and I could see myself forgetting. I don't. And I have a team of people who help me look at my grid and remind me, and I have it on my calendar, but I could still see myself forgetting. That's a different kind of violation than the employer saying, hey, Bosun, you're the PIC for Kentucky. I can see here you're coming up on your renewal. Send me a copy of your new license. Otherwise, we got a problem. I think that the employer that has more resources and a second set of eyeballs, who has a permit to keep track of, and I think that person could be more helpful to the human being who's just an N of one, forgetting from time to time. So put more responsibility on that. That's just my opinion.
So I'm sorry, your proposal for permittees, Mark, was?
Maybe it's a $250 fine for the permittee. To show even in a non-disciplinary situation, we're still concerned about this.
Is that per day, or is just that's the grand total?
I think it's a grand total, because if you do per day, do you actually get into a situation where you could bump past the $1,000 statutory limit anyway?
Well, the other ones have a limit, a maximum.
That depends if.
No, my point is,
Depends
My
on.
point is if you
each
did
is
a-
violation. I'm sorry. Go ahead, Mark.
If you did it, I'm sorry. My point is if you did it per day, could you end up blowing past the statutory limit for violation? So for example, if the violation is not doing all of your CE and there's someone who says, well, you owe us $1,175, there's an argument there that you might have blown past your statutory limit. So, and this is non-disciplinary, where the legislature said, hey, this isn't as big a deal to us as all of the other things you could do in our code. And so I would argue just, this is the first time, standard, just don't do it again. Here, well, it's permanent on your, we've got a record of it as a non-disciplinary issue. If it happens again, you've got more at stake next time.
Thoughts, guys?
I think that's fine.
So 250 here for the licensee. Are we changing that?
Oh, no, I think it's fine as is. As it currently is displayed.
Camp, for 9, why are we limiting it to new PIC? Why wouldn't it be failure to conduct controlled substance inventory by PIC?
We can put that in the additional section if you'd like, but this is when a new PIC is assigned, they're supposed to do a controlled substance inventory.
No, I agree, but there's lots of other times the PIC new, not the existing one, has to do controlled substance inventories also.
Yeah, on May 1st. Yeah, no, I agree with you. And we can throw that under additional. That was just never incorporated in the bill.
Okay. Yeah, I mean, I would just have it for all PICs that way.
I would agree.
On
Well, that's
line
good.
21, we've typically gone to a hearing.
Shipping
not-
into Arizona without a valid permit?
No, line 21,
Oh, I'm
the
sorry.
subpoena.
Yeah. Well, if they hadn't responded to a subpoena, it would go to.
Oh, this is just timely. response.
Timely.
Okay, gotcha.
Where we're calling them again and saying, hey, following up, we sent you a subpoena, you haven't responded. And then they realize,
Boy. Yeah, we sure try, don't we? I'm just saying we make a lot of efforts.
But shipping into Arizona without a valid permit, typically we've applied a fairly hefty penalty on a per item basis, correct?
correct, and you've delegated that authority to me. And it is a consent agreement. If you still want to delegate that authority to me to negotiate, we can do not to exceed $100 per item or something of that nature. And we can negotiate that out.
Would the non-disciplinary instance of this be like a missed renewal by total accident and they reinitiate the license on their own?
Possibly.
It could also be they never were licensed in Arizona in the first place.
Yeah.
I'm fine with not to exceed $100 per item.
I'm good with that. And again, the statutory maximum would be $1,000.
Well, we've done up to $1,000 per item before, though. So each one could be a separate item if we wanted to. I'm not saying I do, but I'm just saying that we wouldn't have to worry about exceeding the limit that way.
I think if we had to get to $1,000 an item, it was pretty serious products, I would bring it before you guys. I don't think I would be in a position and comfortable enough to negotiate.
Right.
I can think of a case we have that we're still in the process of for that one.
Mm-hmm.
Okay.
So are you saying on line 19 that we can say delegate to executive director?
How is 19 different than 17? 19 is they're in Arizona but don't have a license.
Yeah, exactly.
17 is they're outside of Arizona but shipping into Arizona.
Correct, correct.
Or you want to just keep it the same as 17?
Well, and this one is not in the bill. So this is one, I guess, for discussion. Do we want it to be non-disciplinary, to have a non-disciplinary option, or should it just follow the normal process that we've had in the past? Correct.
All these, yeah, the additional category, it could all come before you. You guys that have that additional tool now in your belt to issue non-disciplinary if you'd like. We don't even have to spell it out in regulation. The remainder here.
Is that true? Jean?
I would recommend that any violation for which you seek to assess a civil penalty would be put in rule. The
But
statute.
we may not have thought about every administrative issue, Gene. That's the problem.
I'm looking at the statute. And this is something too that we can, come back to.
Yeah, for example, let's suppose the pharmacy doesn't have a mortar and pestle. That's a technical violation. I would hope we would do a non-disciplinary penalty, if any.
And we could include sort of a catch-all, perhaps. Any other violation that the board determines doesn't threaten the health and safety of the public. We might be able to do something like that.
I don't know that I feel like doing business in Arizona without a permit. I don't know. That's like a pharmacy operating without a permit at all, right?
Mm-hmm. Yeah.
Is that really non-disciplinary?
That's how I feel. I don't think that would be non-disciplinary.
So we might just take that out then altogether. Because at least
Was it on the list?
In number
Is it
7.
on the list the legislature gave us?
No.
Not doing business.
Oh, it's not.
Shipping into Arizona is doing business. At least they're licensed. They may be licensed in their home state, so they still have some sort of oversight. Number 19, they have zero oversight up to the point we catch them.
It could be like the wrong kind of.
Did, wait, was someone speaking? Sorry.
No, go ahead.
Oh, did that bill pass that like redefine the practice of pharmacy to not have to exist in a pharmacy?
Yes.
So, okay, that's good for this. I feel like there could be instances where pharmacists are practicing independently and like there could be an issue of permit, but since that bill's passed, I don't think that's an issue anymore.
Doesn't
I
this
could
come up
see
with
that
like,
being. I was
Sorry.
saying, I could see that being maybe the non-disciplinary factor here if you technically needed a pharmacy. But but that bill
To
invalidates.
me,
it.
that would be where there's a permit required and they don't have a permit. So
Right.
like, for example, somebody is dispensing, say there's a kiosk or something like that, one of the dispensing kiosks, not necessarily a pharmacist working from home attached to a resident or non-resident facility, something like that, because those individuals wouldn't require to have like a license for their individual home.
Agreed.
Doesn't this also come up with the distributors and wholesalers, like the medical gases and the devices? That's where I see this more.
Correct. Again, I think the difference between 17 and 19 is those guys may be licensed and have some sort of oversight in their home state. These in 19, they had no oversight until we identify them.
I'm not really sure how I feel about this one.
We can remove it.
I need to think about it a little bit more, and perhaps it's something that we have a deeper discussion as a full board. But I don't know that one I think is a non-disciplinary in my head, for the reason that you said. At least the others have some sort of oversight in their home state. This is a different circumstance, and I don't know. It makes me a little bit more nervous.
Okay.
There's a bigger risk to the patients of Arizona, since they could be, operating as a pharmacy without a license at all.
Yeah. How about records?
I see that as potentially disciplinary. I think should stay with this current process.
Records,
it can be all over this place.
But this would give us the option, like where there was just something that was misfiled and those kinds of things. I don't know. I kind of like that there is an option. We typically don't get to the point where we do anything until there's been multiple cases of it. So I actually kind of like this being on here. It perhaps sends a message for people to start to get things put together. We've typically, record keeping things have been where there's a complaint brought before us for like a third violation or something very extreme, with like controlled substance losses, those kinds of things. I don't know. I kind of like it being there. What does anybody else think?
I think what's raising concern is probably the invoices in parentheses, like, and that's what brings forth like the loss conversations and stuff. But I think there's probably other record keeping requirements that may not be as like that imminent threat to the public that could warrant this.
Would this include not documenting a consultation?
I think it's more directed towards invoices, not consultation. Obviously, if we see an entire year's worth of records missing, that's gross negligence.
Yeah, that's what I was just thinking. It's just such a huge range of things that could encompass. So.
Yeah, maybe to your point, maybe this is one where we need to have a deeper discussion versus just going to an automatic. I don't know.
Again, it's a may.
Go either way.
It's not a shall issue a non-disciplinary. It's a may. So if we feel that this place is total chaos with record keeping, it's going to come before you guys. But if they're missing something during our investigation, they're missing something or whatever it may be, and where they're inspecting and they're missing a couple of days of records, they don't know where they are. Everything else seems to be in order. We could just slap them on a hand and move forward with it. Why don't I give an orange for us to think about?
Okay.
All right.
Subpoena, I do think there should be something for.
And again, it's timely. It's not folks that just ignore the subpoena. Those guys are going to come before you if they ignore the subpoena altogether.
Maybe 100.
Or do the 50 like we did above. They're still complying. It's just they didn't comply as quickly as we would have liked,
Right.
which delayed processes. I think 50.
50?
Yeah.
They're probably going to get another 50 for not renewing or updating their information anyway.
Change of ownership?
A mix between 100 and 250.
I say 250.
Agreed.
And the last one was what you brought up earlier, Roger, which is identical to new PIC and just a PIC not doing.
I agree with that.
Going back to the remodel and relocation. Sorry, guys, 500, okay? It's less than our customary 1,000, but it is. We felt that it was serious enough. And this is just a one-time buy. But again, if it crosses that line where public interest is compromised, then we'll definitely bring it before you guys.
So in the case that you were talking about with the 797, if somebody were to fail to notify us of a change and they didn't meet the minimum requirements as a facility any longer based on that, and they were operating under that way, you would bring that forward as a separate issue to the board. It wouldn't just be the $500 fine and move on.
No, these are
When there was
strictly
concern for
administrative.
patient safety.
Yeah, these are all administrative. As soon as it crosses that line to patient safety, this doesn't apply.
I would be okay with doing a smaller one for the remodel then, if that's the case, if there was still the opportunity to address it from another perspective. I do feel like the relocation needs to be the higher amount. That's just my opinion.
Is that a fair amount right there?
I'm good with both of those.
I'm good with that too.
All right, now let's get to the easy stuff.
Definitions? Which one's easy?
Yes, it would be the definitions.
So do we want to go through the suggestions that are here case by case, or how do you want to handle this?
I think that may be the best way to deal with it. Just go page by page, and I think Emily did a really good job.
Thank you.
Can
Yeah,
you share the screen?
Yes, I can put it up here.
Thank you.
Thank you.
I can go ahead and just kind of explain, I guess, my mindset with writing a few of these questions or suggestions, and we can work through them however the group sees fit. But in general, like there's two major types of, I guess, highlights in this portion. One of them is pretty straightforward. The ones that have a strike through are definitions I couldn't find anywhere within the book. And by the book, I mean like the Google Doc that's includes like ARS and the rules. And then the ones that I had put some text in red with like a question or term are ones that I thought may either need revision based on like pending rules that we're talking about, or could potentially need some updating based on my perception of, you know, current practice, et cetera. So does that make sense at first, I guess?
Yes.
Yes.
Okay.
Sounds good.
Cool. I also do need to give a shout out to my rotation student, Liz Vong from U of A, who helped me with this. It was definitely not just me. And I think she's watching. So do we want to just go one by one?
Sure.
And do you want to just work through the ones that I highlighted, or do you want to go through every definition?
I guess as we're on the page, if anybody wants to call it, if there's anything else. Dr. Gandhi, did we get any other suggestions kind of as we ask for the homework?
I had one from you, Lori, but I think that's a statutory change regarding flavoring. So we'll work that into a bill for next year or this coming year.
I saw a possible typo that I wanted to bring up.
Okay, so I guess if that's okay with everybody, as we go through the pages, if there's anything else that isn't called out that Emily has not addressed, if there's anything else anybody would like to suggest, let's handle that as we're on the page.
Sure. I think that there was like a reply from Karen as well that kind of addressed some of the automation definitions, and we could just work through those at the same time, I think. So this is actually the first one here. Annual family income is there's quite a few like this. So I understand that we've talked a bit about the new donation rules and like what qualifies as an appropriate donation, et cetera. The current rules reference a lot about income, poverty level, like these types of things. And I'm not quite sure that those are staying or still required with the recent changes.
My understanding is we weren't going to put too many parameters around that bill. That was the intent. I think the intent is let's use these donated medications how we can. So we're saving the water supply, the air supply, addressing shortages of product, and making good use of these donated medications.
So Cam, with that, you're suggesting perhaps we don't need the definition of annual family income.
Agreed. I don't feel that we do.
Mm-hmm.
Okay, agreed.
Right.
Everyone in agreement, we should strike that one.
Okay. Yes.
Cool. So far, so good. Second one is approved course in pharmacy law. That is no longer in the book. There is a similar definition lower down that says, I think, pharmacy law continuing education. And that is still actually in the book. And I think that rule itself may need to be amended because it's no longer a requirement for the law specific. Questions there?
I would agree with striking it.
And we had talked about making a reference to the statute of the opioid CE.
Right. And I think immunization too is the other one. That's like,
Yeah,
if this, then you have to do this CE.
right.
Okay. Next one is definitely more of a question because it's something that I'm not personally very experienced in, but I know when I've taken MPJEs in other states, there's usually a list of facility types that can have an e-kit. Oh, actually, sorry. This is not e-kits, automated dispensing system. This is also one of the definitions that it's kind of hard, at least for me, to discern between all the different types of automation that the definitions are addressing. So first question is this machine only allowed to be in a long-term care facility? Second question is, does this definition, like what type of machine is this defining? And based on that answer, does it need a revision?
Hi, this is Sandy. That definition, automated dispensing system, comes directly from federal law. It's in Title 21 of the CFR. It's the DEA's definition for dispensing systems that they would allow in a long-term care facility. You will actually find the rule that corresponds to that in 701.04.
See, well, Sandy, this is Karen. It is defined in the CFR, but here's where I get confused because the automated dispensing system could be one of those strip packagers that you could use on site at a skilled nursing facility, or you could use it in a pharmacy or a mail order pharmacy even to package up those patient-specific, strip pouch packages.
Well, we have about 6 or 7 different sections that addresses a variety of automation.
Okay.
Automation within the pharmacy itself, you'll find that in 615 and 616. Your 615 will address things like Uyamas and Paradas, and even the proprietary systems that you see in your mail order facilities. 616 would be your countertop type counting devices. They don't store like your Kirby Lesters or your Icons. Kiosks are defined in statute, so you will have those. In 614, you have a couple of different types of automation. You have the filled medication automation that a pharmacy can have that's stored within 20 feet of the pharmacy for patients to pick up. You also have the automated storage and distribution systems, which are your Pyxis, Omnicell types of systems that you see in your hospital settings. And then you have your automation for your emergency drug supply kits, which are a form of an ASDS system.
So defining it where it's placed is probably the best way to go. Is that correct? Because we have in pharmacy, we have in long-term care.
I would think so. I would think you would probably consider the type of system and then look at that specific rule and see if you need to clarify the definitions from that standpoint.
Okay, then that's helpful. Let me go back and take a look at that. And then if I could work with you, then that way I would know where the other pieces are.
Sure.
Okay, check. We got that. So Cam, I sent you that a quick email the other day with the different systems.
Yeah, I think Kim shared that out yesterday with everybody.
Okay, then I'll give it another shot. I'll work with Sandy and we'll see what we can come up with. How's that?
That
What
sounds
about-
good to me, Karen?
What about adding references to all those things? That's great that, Sandy can name them all, but if we had a reference here, it would be, I think, helpful.
Does it need to be in the definitions, or can it be in like an FAQ or something like that, perhaps, that we build out rather than putting it into the rule?
Well, we have here, like, even just scrolling up to tiny bit assisted living, it says as defined in blah, blah, blah. I don't know. I just think that if I'm saying, well, is this considered an automated dispensing system? And then it references where I can find more information. To me, that would be helpful. I don't know. I like references.
I like that idea, to reference it in the definition. What do you think, Sandy?
I think that would be fine. And I would also say, in response to things like the ASDS, when that particular rule was put into place, they didn't then open the hospital section and reference that. So when we open the hospital section, this should be referenced within that, because those are the primary locations which use these types of systems.
Okay.
Okay, anything else on that one?
I-
So do we want to add references under the ASDS then too? Based on that same logic?
I think we could look at all of the definitions for the automation and do a rule reference.
I think that would be helpful. The other part of my question, Sandy, for that one definition that we started with, automated dispensing system, is a long-term care facility the only place that can be, or is long-term care facility an umbrella? Like, does that include assisted living? Does that include skilled nursing?
Well, we kind of use long-term care and skilled nursing interchangeably, but not assisted living. So the rule right now would address just simply the long-term care facilities. That's something that you would have to look at. Our long-term care facilities have always historically followed the DHS licensure for long-term care facilities. The DEA has a little bit expanded definition of what is incorporated in a long-term care facility. So that might be something that you would want to take a look at.
But I think in other states, they're using these automated systems in freestanding surgery centers, freestanding hospices, drug treatment facilities, rehab, alcohol and rehab facilities. So do we want to add all of that into the Board of Pharmacy type care settings, or?
Well, I don't think we could put it in any other type of facility that's an extended residential type of place based on the DEA. So outpatient surgery centers and those types for an ADS system, at least I would be concerned with.
Okay.
We had a meeting with DEA actually yesterday, so we can work better together. And this was discussed yesterday. They do have restrictions on residential type locations having these type of systems.
But what if it didn't contain controls? Then it would be outside of their purview. Like if it were to hold things like psychiatric meds, non-controlled substances, blood pressure medicines, those kinds of things, would the DEA have those same concerns? Probably not.
No, they wouldn't. I think the only thing we'd be concerned about is we typically today don't know where a lot of these units are. And so we don't know if they're following non-control guidelines versus control guidelines because we don't visit them today.
I think this is like, I want to make it clear that I don't have an opinion on these things. I think the place where I'm coming from is that I am confused as to the type of machine that each of these is describing because their names are so similar, and the definitions are complex and broad, and maybe that's appropriate. But I guess one of my questions is like, is this machine intended to be in some semblance of a healthcare facility that does not have a pharmacy, and a pharmacy is responsible for stocking and maintaining the contents?
Yes, the drugs in the system are the provider pharmacies stock.
So that clarifies what type of machine that is for me, at least. Okay.
So Sandy, I have a question. For facilities that are licensed by Arizona Department of Public Health as outpatient facility, will these facilities be permitted to have Pyxis or Omnicell station by DEA?
Like a clinic, you mean, Kevin?
Like a clinic, like an outpatient clinic, correct?
It's not the you're talking an ASDS, the storage and distribution, like a Pyxis or an Omnicell system.
Yeah.
Yeah, it's not the fact that they have the system itself per se. It's where and how they get the drugs to stock those systems in outpatient settings.
Okay. So I know right now in Arizona, the freestandings have Pyxis or Omnicell, but all these freestanding emergency rooms are licensed under the parent hospital. But I'm not aware of the fact that freestanding emergency rooms that are standalone facilities are able to have Omnicell or Pyxis station in these facilities.
Again, they could probably have the system per se, how they get the medications would probably be a wholesale distribution to the medical practitioner of that facility to stock.
Mm-hmm. Okay, thank you.
Okay.
Let's go on to the next page.
So next definition is caregiver. My mindset on this one was, I don't know if that's necessarily like a relevant term in all cases. So for example, I could have someone who isn't technically my caregiver picking up medication for me. So maybe a family member or I don't necessarily know if the person needs to be sick or disabled to have a caregiver or have someone else pick up their meds.
Right. It looks to me like it's a typical definition, so not sure it would be needed to specify. Just be stricken altogether.
I can give you some history. The language used to read patient's agent, and there is a counseling task force back in early 2000s, and they changed the term from agent to caregiver at that time. I can't, however, give you the reasoning behind it. I just know that it was changed then.
That's what I was just going to ask, Cindy.
I think the reasoning was people didn't want to counsel an agent, meaning if the taxi driver was picking up the prescription, we all agreed it didn't make sense for the pharmacist to be counseling the taxi driver. The thought was you had to counsel either the patient or the caregiver, but not someone else picking up a prescription.
And I agree, that makes sense.
And I guess if that's still the requirement on the counseling, I just can't remember if it is, it makes sense to define what a caregiver is then.
Yes, it still has that language in there.
Okay, then I would say we leave it then.
But to Emily's question, does it need to have the word sick or disabled? We could just strike that part.
True. Because I might pick up a prescription for my husband that isn't sick or disabled, but just pick up his prescription, and it might be totally appropriate for the pharmacist to counsel me, but
right,
maybe not if I was the Uber driver.
Exactly.
That works. Okay to move on. Next one is compounding and dispensing counter. So this is one of two definitions of a counter, countertop. I know that I think in past meetings of this task force, or when there was discussion about creating this task force, I think there was appetite to potentially revise space or revisit space requirements. Yeah. You know, there's a lot of deviations for small hospitals, et cetera. The countertop rules are very, very specific, saying this amount of countertop per person. So there's kind of like that notion. And then there's also the notion that there's two definitions of countertop. And I can find the other one real quick. Let's see. It might be called compounding counter.
Well, there are two definitions. It's the pharmacy counter working area. I I don't know this for a fact. I think they kind of separated them because the definitions are rather lengthy if you compare the two together. When we're looking at a pharmacy and measuring countertop space, that pharmacy counting working area gives us a clue that, well, not a clue, it tells us that we don't count countertops that have a lot of fax machines and computers on there. We can't count that as working space because it's not open for them to actually do any compounding or dispensing on. So you probably could combine the two and then do a revision within Article 6 and just have it reflect the one.
Like
But
a
I-
countertop, oh, go ahead.
But I think to your point, Emily, do we even care how much counter space we have? As long as it's safe based on the type of practice, should there be a minimum amount of counter space?
Yeah, I think that makes total sense, right? How you could say that you can define counter space. You could say counter space is free space available for dispensing activities and compounding that isn't taken up by, I don't know, fixed objects or something. And then potentially, if there's appetite, the rule could then say there needs to be appropriate amount of counter space for the type of pharmacy that you're practicing. But is that like, I don't know if that's just my idea.
Appropriate counter space is hard to do from a compliance standpoint. And I have unfortunately gone into many pharmacies that probably did not have an adequate amount of counter space.
Sandy, just to play that out, if they don't have enough adequate counter space, we think that results in, or maybe it actually it does. We think that creates more likelihood for errors, things being misconnected up and misappropriately dispensed.
I would certainly think so. I mean, I can't link any of my complaints to that specifically, but we do make notations on inspections about pharmacies that are in counter spaces that are cluttered and floor space that's cluttered, those kinds of things. So it does inhibit what you can do from a pharmacy practice standard, I believe.
I think that comes back a little bit to unsanitary conditions though, too. So if it's because the counter space and floor space is cluttered because the pharmacy is disorganized and not neat, like some of the cases we've seen, to me, that's a different circumstance than saying that you have to have a minimum amount of counter space to operate. So for example, a very low volume pharmacy, I'm thinking of one in particular we licensed recently that only had several products. If that was only unit of use products, is probably not going to need as much counter space as a full service community pharmacy that sells the full gamut of products. So I don't necessarily think that those people would have to have the same amount of things to do the business safely because of the type of business that they're doing. Again, somebody that's doing compounding is going to need far more counter space than a retail pharmacy that isn't doing compounding to do it safely. So I don't know that it's hard to say. I understand what you're saying from a compliance standpoint. It's hard to say, how do you measure adequate? But I think every pharmacy is different based on the type of business they do. I think the practice of pharmacy has evolved so much that not everybody's the same anymore.
3 square feet of counter space is rather minimal when you take a look at the requirement.
Isn't there also per person though in certain permit types?
When we do a pharmacy, we look at 2 things. We look at the square footage of the pharmacy because that gives us a maximum number of personnel. And then we calculate how much counter space is in there to make sure that it can support that number of personnel.
This is Kevin. So Lori, I agree with you to some degree, but in my opinion, from my experience as well, whether you're a busy pharmacy or a not too busy pharmacy, certain products that we receive comes in fixed size. For example, when we want to compound a lead gel, the lead gel will require us to have enough space to have all the equipment that we need to compound the lead gel. So in that case, I think we should have a minimum square footage requirement. Like Sandy said, minimum of 3 square foot, right, Sandy?
Correct.
So, yeah, so based on my experience, one of my hospital, we only have 12 licensed beds. That hospital, the volume there is very low. But at this hospital in Mesa, we have 50 beds. And our volume here is busier. Whether we're busy or not, we still compound the exact same product. That's why I think having a minimum of 3 square feet space would be very helpful for our technician and our pharmacist. In addition to that, I think we also put in a requirement that the compounding space should also be next to the sink. Because otherwise, you're gonna have the technician would have to walk across the pharmacy to the sink if we don't put that in writing.
I don't think that's reasonable for every pharmacy to say that. I think when you look at most community pharmacies, very few is that the case.
In the pharmacy area is where the sink has to be.
Mm-hmm.
I agree, it needs to be in the pharmacy, but next to the counter, I don't know. I think that might be a little bit too specific. I don't know, Emily, I kind of like your suggestion of maybe just defining what counter space means, and then we can address what the specific requirements should or shouldn't be later.
Yeah, like it could be, yeah, exactly. So that could actually be handled in like the deviation portion of a discussion that we have in the future of like the actual requirements of a space. But I figured I'd be remiss if I brought up, like, if I didn't bring up that this board has talked about like space requirements before. I think the things that I've heard are it needs to be a dedicated space for dispensing and or compounding, needs to be free of fixed objects. But I think Sandy added something important as well, that it needs to be free of clutter.
Mm-hmm.
It needs to be sanitary.
Right, and do away with all the lists. Just distill it down to what you said and do away with the listing out of what items it could be. I think is how it should go. And can they be combined that way, since we're simplifying and distilling it down to the important items?
So the definition would not be compounding and dispensing counter, it would just be counter space or pharmacy working counter. Obviously, it would need to be renumbered or resequenced if we change where it is alphabetically, but.
Pharmacy counter space.
Yeah, I think pharmacy counter space makes sense. So it still has the intent of both definitions, creating space to do pharmacy work, but also qualifying that space needs to be clear and clean. I think it's just a little bit less confusing.
I liked that, free of clutter.
Unobstructed working space, or so to Sandy's point, the computer printer that takes up 2 feet of the 3 feet of space is not going to be considered part of the working space. Sandy, you get where we're going from an intent standpoint here, right? Because you're, I think, the one that's going to draft it, right?
I think I can come up with something.
Okay, great.
Just so we're all clear, we're setting forth here the minimum standard. Obviously, pharmacies can do lots more and do things better. We're just trying to set what would be the minimum standard here.
Well, minimum definition, yeah.
Right. I just think there's so many different things that can go in here. I would love to just use the word they should have reasonable space, but I understand pharmacists and appropriately regulatory, that's lots of different interpretations with the word reasonable.
Yes.
All right.
Anything else on that one? I don't know about anybody else, but we've been going for like 2 hours. So I think a quick like 5-10 minute bio break is in order, at least from my perspective. I need it.
Good. Yep. Let's do it.
Cam, how long do we want to do? 10 minutes?
Yeah, I think so.
Okay.
So we'll come back at 1:15. All right, welcome back. Dr. Gandhi, do we want to do attendance or just keep going?
I think we keep going. I see everybody back,
Okay,
or I
Okay.
see them at least on our Zoom call.
all right. All right, do you want to pop up the definitions again for us to keep going?
Certainly.
All right. Next one is computer system audit. There's two definitions of audits. This is computer system and then single drug. Both of them aren't actually used. I think that at some point, I mean, I'm just guessing, but they must have just been enveloped into things that inspectors can do and probably don't need a definition anymore.
Sandy,
Kristen, you're on
Cam,
mute.
have any thoughts there?
The CRT component, I probably agree can go away. I'm not so sure about the computer system audit. But thinking back, I don't know that I've ever used that in any kind of citation. So it through all the years. So I'm thinking that it probably was relevant a long time ago and it really isn't now.
There's other, like, the term audit is obviously used quite a bit, but not this exact term. So I'm kind of just wondering if it became broader.
Probably.
Like, you need to have policies and procedures for how you audit your inventory. You need to audit like certain pharmacies for compliance. It mostly comes up in the sense of inventory. Just the term audit on its own.
Sandy, do you see any harm in removing it?
I don't. We still have the definition for the single drug usage report, which is one of the components of that rules section that we utilize all the time.
Oh, single drug usage report, correct. The single drug
So-
audit isn't in there.
Right, and that's,
Okay.
and I'm looking at the rules, so I'm thinking that we're probably safe to eliminate that one.
Just for clarification, Emily, are you referring to the auditing of controlled substances that are stocked in Omnicell or Pyxis? When you say computer system audit?
So what I think, I'm not sure what this was used for at some point, but I think that this was, pharmacies need to be able to show records to their
Mhm.
inspector. And at some point, I think this rule, this definition must have been a portion of that. To date, like, as long as inspectors still have the authority to ask for a report on dispensing, which, like, I would definitely hope that they do, since this definition doesn't exist in the rule. Like, it needs to be somewhere else.
Right, so just to share with you and the team the current practice that I have set up here at the Dignity Health Hospital. We have, we are requiring nursing staff to conduct cycle count on all the narcotics on a weekly basis. And these numbers are captured and documented in all the Pyxis station. I think it is a practice that I encourage all other hospitals should do, because it helps alleviate a lot of burden on the PIC or the pharmacy director. Because when there's diversion happens, if you don't do weekly cycle count, you have no idea where to begin or where to start conducting the investigation. So having said that, I don't think we should remove the computer system audit if it's pertaining to controlled substances that are stocked in Omnicell or Pyxis.
Kevin, I think the point here is that it's not referenced anywhere in rules. So what is the point of having a definition that has no requirement?
And I just went through and quick read part of 408, which is your computer system. I don't think it's needed. I think what this was intended to do back at the time when we still had some pharmacies that were doing manual systems and others that were going to the computer system, because this is a very old definition, that they had to have a way to assess the computer system to make sure it had all of the requirements within it. You'll find a listing of what a computer system has to have within 408. So I think this can go away.
Okay.
Great, thank you. Next definition is CRT, which I believe is intended to describe.
Emily, can I
Yes.
interrupt you just a
Yes.
second, since I have a question before your CRT?
Yes, of course.
If you go back to and this is just one that's always bugged me, and it maybe it's not we can do anything. Why do we track things in terms of contact hours and CEUs? Why can't we just say they need 30 hours of continuing education and an hour is a 50-minute program? But why do we have this 3 CEUs? I constantly have students confused by this.
Yeah, because right here on this page, we have 1, 2, 3, 4 kind of all
Right.
different definitions of the same kind of thing, really. So why not just have one definition of what CE is and use that same definition in all of the CE rules?
And make it an actual hour. I don't care that an hour is 50 minutes, but why did the requirement in Arizona is 3 CEUs, which equates to 30 contact hours, which is 30 50-minute sessions.
I think when Cam and I looked at this, when they were doing the last revision for CE, I think it's still listed this way under ACPE. Not that I think that personally that it doesn't make more sense to change it, but I think that was the rationale.
I was wondering if they could be condensed. So almost defining one of these things and almost kind of using it as a header to some of the other like more specific terms, like defining continuing education. And then having activity just be listed in the rule or unit. But it is like, it would need a lot of revising of the rule so that it all made sense with one definition.
So I throw it out there. You're right, Emily. It needs a major cleanup, and it's messy. Whether we still use the CEU term or not, but putting them all together.
Which I think is kind of the point of this. My goal of this is to add clarity, right? So I think that this has probably been a definition that's evolved over time with the way that it's referenced in different places. So instead of cleaning up all of the language, we've just kind of continued to add definitions in to solve the problem. So I don't know, maybe as we're looking at the continuing education rule, do we see if we can't clean it up and try and combine all 4 of these definitions for one clear requirement that would be much easier for the licensees to understand? I think there could be some benefit in that.
Yeah.
Maybe a topic for our next meeting, so we can really tackle it.
I think CE we have later for this meeting even, but I don't know how we're going to do on time.
Yeah.
Okay.
All right, next is CRT, which I think is an old term for like a TV or computer screen. It's used.
That's offensive, Emily. That's not enough.
I'm sorry, I don't mean to offend by any means.
For the old folks.
I struggled with this one personally. I don't know what it says about me, but I think that the intent here is it was in some of the audit definitions saying that pharmacies need to be able to have a display to show like what they've dispensed or what they've used, etc. Other places it's used is in this definition for slight readable, or sight readable, sorry. And then in the computer storage, it just says via CRT display. I don't know if it's appropriate to just change that to say like digital display or visual display. Those are the only places it's used.
We also have the term microfiche later in the meeting and later in the logbook too. So, you know.
Sounds antiquated. Let's strike it.
We
if
use microfiche in my time in pharmacy even, so, you know.
I'm not gonna lie, I don't know what that is.
Oh my gosh.
Oh, that's terrible.
But I think my suggestion here is removing the definition for CRT, and in the few other references that list CRT, putting visual or digital display. Is everyone aligned with that?
A second.
I have no concerns with that. I think as long as the information is readily retrievable to the inspector and to the board, I don't really care if it's via a CRT or a printout or an email or whatever. I think as long as the information can be reproduced, I think that is sufficient. And who knows what the technology will be in 20 years from now.
Right.
And I'm still rendered speechless having somebody point out how old I am that they don't know what microfiche is.
I apologize. This is obviously on me. This is my problem.
No, it's just time moves on. But yeah, it got called out today.
So again, do we just eliminate CRT since it doesn't exist and redefine something somewhere else?
Yeah, Emily, what did you suggest?
I think either
Visual
like
display.
visual display, and that would go into the site readable definition. And there's two other places that use CRT. Online retrieval. So you could just say via visual display. And again, online retrieval via visual display.
Do we need any of that, or can we just reference readily retrievable where all of the documentation is required and just get rid of all of that?
It just makes common sense. We just get rid of it. I don't know how else you can
Yeah, I think let's
really retrieve anything.
cut it.
Okay.
These are the sections in the computer system data storage that talk about pulling up original prescription order information and patient profile information. So that would need to be available, whether you say CRT or visually.
Are there any other ways that it could be provided? So like on a computer screen or the hard copy printout is in the rule. Is there any way else that you guys get information? Email?
Yeah.
Well, and I think let's not be so limiting because we don't know what the technology will be in the future, right? So what if it was available via SharePoint or some other secure method? I mean, we don't know what technology is going to look like in 5 or 10, 20 years. So if we're trying to make this more modernized, I think just readily retrievable and leave it open to changing the ways the businesses operate. I mean, I think at the end of the day, as long as the information can be provided in a timely manner to the board, should we care how it gets there as long as it's correct and timely?
I agree with that. Then we don't have antiquated terms in here that have to be updated.
Then you're to the point where you have to define timely or readily retrievable, just as you do in other sections for provision of records that are not available on inspection. And some of these records could be quite lengthy, but that would be a facility concern at that point in time if that's the direction that you go with.
So where it's used says that you need to be able to provide a retrieval of the prescription order information and the patient profile. What if it was just what if we just said in a means that is acceptable to the inspector, or in a means that is accommodating to the material?
I think it could change by the inspector too.
Yeah,
Yeah.
Those are two ambiguous of terms.
Okay.
And if you had one inspector versus another, what if they wanted different things because they liked one format versus another?
Yeah.
I don't know. I think we can safely remove this definition, I think, for the purposes of this, and we'll get back to record keeping, I think, later in the discussions, probably.
The term display will still be there if we even just remove the term CRT. So it would be providing online retrieval via display or hard copy printout if we did nothing other than strike the term CRT. The only place it would need to be revised is in the site readable definition, where then you could just put display like the other rules.
Okay, sounds good. Let's get rid of it.
Okay, let's go back up for a second. I was just looking at the definition of a day. Okay, I'm good with that.
Okay. Digital signature, that definition references a statute that I could not find. I think it's since been deleted. So I did find that there is a definition of digital signature in, I think, the pharmacist manual. I would think that that would be appropriate to reference instead, but I just don't know if that's legally acceptable.
It is. We have referenced CFRs before.
Do we need to reference it, or is it implied since it's DEA when you use the digital, when you use a digital signature?
We use the digital signature in our regulations. We typically do define it.
Okay.
And we could actually reference digital signature as defined by 21 CFR in the rule itself in a regulation where it identifies it. But if it's identified in multiple locations, we're just adding that repeatedly. That's the problem. So it's easier to define it.
Okay, then I would be aligned with changing it.
I just have a question. We have electronic signature coming up shortly thereafter. What's the difference between the two, and why do we need both?
I didn't even catch that myself.
If you just scroll down a little bit, you'll see electronic coming up. And it has a different reference. And I'm trying to understand why we need both of them.
Let's see. It says That reference says electronic signature means an electronic sound, symbol, or process that is attached to or logically associated with a record that is executed or adopted by an individual with the intent to sign the record.
I just think for the normal person, electronic signature and digital signature are virtually the same to them. And if we're using them for authenticity, we should be able to combine them in some
What
manner.
was the citation under electronic record ARS?
The electronic one is 44.
7002.
7002.
So I think that's more for allowing like electronic signatures for like an application, it seems like to me, because this is under just general trade and commerce statutes for the state of Arizona. Versus the other is what allows for authenticity for a controlled substance to be submitted electronically by the DEAs. But I agree, it's kind of confusing.
I'm also not sure. The term electronic signature is used in the rules. Digital is only used once. So I think they're used somewhat interchangeably, like basically the signature on a prescription, at least one time each. I don't know if there is some type of qualifying very like specific data reference for the DEA version, if there is some specific controlled substance provision to that definition versus for a non-controlled prescription. I'll open the DEA definition.
There's also another variation of this definition further down, verified signature or signature verifying. So there's 3 definitions of signature in the rules.
Maybe someone can take this one as homework. Not me this time.
Because the electronic one goes back to, like I said, it's a statutory definition under the general Arizona trade, means an electronic sound, symbol, or process that is attached to or logically associated with a record that is executed or adopted by an individual with an intent to sign a record. So I'm thinking that is more like for example, applications or something like that, but I think it could also be used perhaps for a signature for a prescription. But that seems more in line with our 3rd definition of verified signature.
Lori, there's a definition of electronic signature under 41-351 as well. I know the board's rules don't reference that one, but it appears several different places. And that has to do with notary, like notary signatures and notary publics, but it gives a different definition of electronic signature. I think it's electronic method or process that through the application of a security procedure allows a determination that the electronic signature at the time it was executed was all of the following: unique to the person using it, capable of verification, under the sole control of the person using it, and linked to an electronic document to which it relates in a manner so that if the document is changed, the electronic signature is invalidated.
Yeah, this is Mark. Seth is right. I've looked at this before for different reasons, and Arizona does describe signatures in in lots of places in the laws. What if we created sort of a catch-all signature definition and included something to the effect of shall be compliant with the requirements of digital, electronic, verified, or manual signature as described by Arizona law, and we can either reference the statutes like they are now, including new statutes that may have been added since this rule was written, or just leave it as allowed by Arizona law, something to that effect. That way we don't get hung up on, is it a digital signatures, electronic signatures, and verified signatures, and manual signature? Well, all of them are all right if they're consistent with those terms in Arizona law.
And I agree with Mark. And if you look in statute in 1968, when they talk about electronically transmitted prescription orders, they use the term electronic or digital signatures. So does ARS 41-132. It mentions both as well. Yeah, that one.
Oh, I couldn't find that one. Maybe that was just my mistake.
What do we think? Do we want to try and clean this up and try and bring it? Do we need to have multiple definitions since it's referenced different places, or do we need to just clean up the rules to match one definition?
To have it match one definition.
And can we have one definition since there's different things probably federally and then state depending on the type of document?
Well, 1968 is our statute for prescriptions.
True.
That states digital or electronic.
And then it's in Rule 2, R423, 411, I think.
Can we just define signatures as being
407, I'm sorry.
digital, electronic, verifiable as defined by Arizona law
And federal law?
and federal law?
That sounds good. Simple.
So it's all under one bucket and we're not looking for 3 different definitions.
Right.
So reference the CFR reference and then reference the Arizona statutes.
Yeah.
Everybody good with that?
Sounds good.
So next one I have is, I think, more of a conceptual discussion that probably needs some more clarification. I think in modern practice, a lot of pharmacies do some degree of split verification, or there may be multiple pharmacists available doing different parts of the process, or one pharmacist could have checked the original and another one could have checked the refill, something like that. Right. And the term dispensing pharmacist, I don't know how that applies to this type of arrangement, right? Is it the pharmacist verification that happened at the dispensing step? Or is it more nuanced than that?
Yeah, and it says after the complete preparation, also that you're initialing the bottle, which doesn't necessarily happen.
Yeah, I see this as the product review step of making sure that the right thing is in the bottle, not necessarily the DUR or the data verification with the upfront portion of it. However, a technician can do this with the technology assisted product validation rules as well. So is this really completely relevant anymore?
Right. That's what I was wondering. Would it even be necessary to have this definition?
I think a pharmacist is responsible for any verification that they provide, or anyone is responsible for any verification that they provide.
The
I don't
step
know.
that they provide, the step
Yeah.
that the step that they completed, whether it's split process or the start to finish, whoever did those steps is responsible.
Exactly. Could, like, is the appropriate way to handle this to revise the definition to say verifies the proper product is dispensed? Or it could be the,
Well, what's the value of keeping this definition at all, just kind of in general, before we start breaking it down? This,
Because the other part of it too is, what about in a telepharmacy too? I mean, how does that play into the telepharmacy rules? I don't even see this referenced in the rules, like anywhere in the rules, dispensing pharmacist.
there's
It's
one in statute.
407, it's in name of initials of dispensing pharmacist. So R423 407.
can that just be changed to pharmacist, and then we take out this definition?
No, but I think you need unless we revise 407, I think you have to say who the dispensing pharmacist is. We would have to clarify that doesn't necessarily have to be the same person, right? I don't know.
This goes to like a discussion too of when there's initials on a label. I think everyone on this call knows that that person has probably not verified each portion of the prescription, right? As long as the pharmacy has a correct record of each person who did each step is really how you find out if something went wrong.
Yeah, then, I mean, most people don't initial labels, right?
I think the label has to have I think it's usually done digitally now.
Right.
And it's like the last person involved, like their
Right.
initial probably goes on the label.
Because I'm old, I do initial out of habit, but I haven't been in a pharmacy for years. But yeah, electronically, it breaks down who was responsible for what. That's why initials that are illegible most of the time really don't help.
But to your point too, Emily, I think a mail order pharmacy, they use the PICS initials. And it might not even be the person on the actual physical label, but it would have the regular person, the person who was involved in the steps involved in the dispensing record. But I think the PICS initials are who show up on the actual label, which
That's
what's
very
the value of that for a patient?
Yeah.
Anyway.
Right.
Yeah. I think like if anything happens with the prescription or if there's any question with a prescription, you pull up every step that's happened with it,
Yeah.
right? All the PV1 steps, all the PV2 steps, any doctor calls, blah, 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 blah. And you kind of take it from there.
You pull that up on microfiche, or do you pull that up on?
Still do not know what that is. On a computer.
We all know what to get Emily as a gift for her participation in the task force.
I'll send out my birthday after this. Not with the year. You already have an idea on that one.
I don't know. I mean, what's the danger of removing it? I guess.
Yeah. What's the
Well, in 408, where you have the logbook that requires your dispensing pharmacist, keep in mind that logbook is based on federal law 1306. So it talks about the dispensing pharmacist maintaining that initials of the dispensing pharmacist for each refill. And then you have the logbook requirements as well.
Wouldn't you need to maintain like every pharmacist involved? Not just the dispensing one?
And technician for that matter.
Well, your technicians only really come in when you start talking your shared services component or your perhaps that verification component now, since you had that change, but on any other system, no, we would not require that technician's initials to be associated with the dispensing.
Doesn't it show up in the computer assisted verification?
Yes, the technician verification component, yeah, and
Yeah.
shared services. But if they're not participating in that, if I looked at a computer system in a pharmacy and didn't see technician initials, that would be fine because there's no requirement for it.
The ideal would be that each pharmacy keeps track of each person who was involved in the filling of the prescription, from data entry to tracking to everything else. And that be the requirement. But the problem is we're trying to still also be in compliance with some federal laws.
And I agree that would take everyone to basically the same requirements that you see for the shared services rules, which is tracking the prescription at each stage of its processing.
Well, then maybe take out some of the phrases then at minimum about after the complete preparation and initials the prescription label.
The places that I'm seeing it is in like the prescription requirements section, the refill requirements section, the computer records section.
407, which is prescription
requirements.
Yep.
And then, yeah, it's only in those sections. So like, you know, dispensing, refilling, and then the computer records. The computer records, I would think that I think in most of these places you can just call it the pharmacist.
Again, keep in mind for controlled substances, the DEA regulations requires the initials of the dispensing pharmacist for each refill.
So it doesn't sound like this one is broken then, other than maybe the initials, the prescription label. I don't know. Maybe we're making it more complicated than it needs to be.
So it would still require, there would still be identification of the pharmacist in the computer records if you just removed the word dispensing. It says is signed and initialed by each dispensing pharmacist. You would change it to each pharmacist. Or each involved pharmacist, maybe. My intent here was just clarification on who this person is and the role that they play, I guess. If I'm the only one that's confused, then it's okay.
No, you're not alone. I mean, I've said the same thing multiple times, so I'll be quiet. Sandy, you're uncomfortable with eliminating this. Is that what you're saying?
I think we might be better served to revise the definition of dispensing pharmacists and perhaps consider definitions for data verification pharmacists and those types of things. Because I will say, when I investigate a complaint for, say, a dispensing error, I do look at what phase of the process that error occurred, whether it was the data entry component or final verification or counseling and so forth. So, so perhaps we could think of it in that nature and just do some revisions so everyone is clear.
That makes sense to me, because I think ultimately at the end of the day, we want to hold the person accountable for the step that they did. So maybe delineating the different parts of the prescription would be smart.
Or there could just be a statement, right, that says, like, pharmacists are responsible for the verification step that they perform. Instead of creating a bunch of different definitions for each step. Because like the steps will probably change, right? There will probably be more steps or new steps.
True.
We can revisit this one maybe with the asterisk of the initials, because the initials may be electronically generated.
Also complete preparation. I feel like if you're the dispensing, you may not be the one that completes it. Unless I'm reading that incorrectly.
We'll take a look at it.
Okay.
Great. Thank you. Sorry for the thrashing on that one. So emergency drug supply unit, to me, this looks like it is supposed to be like an e-kit. So I guess that's question one. Two.
You skipped over earned income, unless that was on purpose.
I think that is in the same donation rules, and we had talked about annual income first.
Yeah, I think we strike that one. Everyone in agreement?
Yeah.
Electronic signature, we were going to look at with those other definitions too, Cam, if you want to make a notation there just for your own records.
Before we go to the next one, can we talk about eligible patient? Because it's a really narrow definition. And if we're going to keep this, and I don't know why we need it, I'd call it eligible immunization patient. Eligible patient just sounds way too broad for this narrow definition. But I don't know if we even need it, is the question.
Mm-hmm.
Yeah, it could just be in the rule itself, right? Part of the immunization process is determining if someone is clinically eligible to receive that immunization.
Yeah. And I don't feel like that's something we need to specify a definition for. Someone's eligible. We all know what that means.
We do use it in R423-411, that term, eligible patient. But it defines.
It's not outside of the normal use of the word eligible.
Yeah, I don't think so. And it describes how we determine if a patient is eligible by looking at, the CDC guidelines, et cetera, right in the rules.
I'm not sure if the definition does anything for me, really.
Yeah.
I think it's actually spelled out a little bit more clearly in the rule than it is in the definition, to be honest with you.
Strike it.
And this could be an exercise too. I don't know if this is the right way to go about it, but when in these ones that we are striking or revising, revisiting the sections in which they were once used is going to be the exercise where we like really clean it up. So that could be a next step.
Yeah. We have to check out the partner piece.
To move on?
Yep, emergency drug supply units.
Right, okay, so I think this is intended to be an e-kit. Again, on my MPJEs in other states, I feel like I have to know what types of places can have e-kits. And I feel like some states have lists longer than this. So I just want to make sure that this is an updated definition. Right now it says long-term care and hospice inpatient. Could it be in a regular type of hospital that doesn't have 24/7 staff?
Hospitals would generally use an ASDS like a Pyxis rather than be considered emergency drug supply, and the hospital regulations handle that. Right now, our rules have these emergency drug supply units only in long-term care facilities and hospice inpatient facilities. There is probably a need to add inpatient behavioral health facilities because there have been some deviations granted for those. And that would be Rule 702, I believe. That would need to be updated if that's added to the definition.
I would agree with that, Sandy. And then what about the facilities that we've had, like the prisons, where we've had some of those deviations come before us?
Doesn't the DEA define inpatient behavioral health to include prisons? Isn't that what they indicated yesterday, Sandy?
I think so, but I don't think they were talking about emergency drug supply units. I thought they were talking about ADS systems. And that might be something we have to clarify.
Those two devices are intended to do the same thing, but one has additional controls. Is that correct? Just so I'm understanding it properly?
Yeah, the hardware is the same. The software has more controls if it's for all meds than if it's just for e-kits. But in other states, it is, we are using these things in prisons and correctional facilities. And they do store controlled substances, and the DEA has said it was all right. So Cam, I think you're right. I think underneath the DEA regs, it does include prisons because we're in there. So hopefully. Sandy, what do you think about assisted living? Is that not covered? If we're going to change it to expand it to drug and alcohol rehab facilities, would we extend automation to an e-kit in, let's say, an assisted living facility?
Roger or Mark may know more about this than I do, but the assisted living facilities have always been a little bit problematic because there's so many types of assisted living facilities in Arizona, and we can't tell from the permit what type they are. Are they simply an independent living facility, or do they have more nursing care similar to, a step down from a long-term care facility? And unless they would have 24/7 nursing care in the past, they would never approve to put e-kits in assisted living.
It's correct. Arizona doesn't license them well, so it makes it hard to track what you can do for each one.
Oh, because they are using these automated systems as e-kits in other states in assisted living facilities, but I bet it hinges on the licensing per state. Okay, Can we expand it?
I'm not sure how we would go about determining what kind of services the assisted living facilities had, since we don't inspect those facilities.
Okay.
Should an alternative we look at if we want to allow that be legislative work, perhaps next session, something like that, where we have a licensing for those types of facilities, for those types of machines to allow it? I understand the concern with, since we don't inspect those facilities, but if it's something that we think is needed for the community, should we be looking at a way to solve that gap?
We had asked DHS at one time if they could provide us with some kind of guidance on the assisted living facilities, and if there was a manner for us to determine who did have, more routine nursing care versus others. But I don't recall that we ever got anything from them that addressed that.
Well, maybe we could ask, because this whole COVID situation has brought to light some of the issues that some of the residents in different care settings really need medications right away. And then if they don't have them, how are they going to get them unless they go out of the facility or the pharmacy gowns up, gets all the PPE and comes in and delivers it? Whereas using automated systems, they can just electronically get the order and assign it to that patient or that resident. So I think there's been more of a push because of COVID, or more of an awareness of the need. So, okay, maybe we could ask next session.
Sounds like a good next step. Further thoughts on this one? We should probably have a list of things that could potentially need legislative changes if they are like.
I agree. I was just going to say that, like a parking lot list for legislative change.
Yeah.
I'll put that in my notes. Next one I think is pretty straightforward, and maybe I'm just being too granular here. Extreme emergency means the occurrence of something that constitutes a threat. All I was thinking is, if the fire alarm goes off, we don't know if there's necessarily an occurrence. Can it be also a threat of an occurrence? Or if there's some sort of like patient or like, I don't know, customer threat, it doesn't need to occur in order to basically leave the pharmacy.
I think the purpose of this, Emily, and correct me if I'm wrong, Sandy, is to allow somebody to enter the pharmacy without the pharmacist present.
That's correct.
So typically they wouldn't be, well, I guess they might be entering if there was a fire alarm, but typically you'd be exiting the building, not entering the building. But if there was a fire and somebody needed to put the fire out, obviously they would need to enter the pharmacy without the pharmacist.
Yep, that's fine. I was just wondering if it needed to be clarified. Sounds like it's good. Next one is also related to like the income stuff or donation. So good to
I just quick comment about that. It's such a bizarre, and maybe we're not going to change it, or we're not going to use it, I guess you're saying maybe. But it was a family is a group of people who live together or related, or who don't live together or not related. Just a little side note, it's just amusing to me.
I think we can safely strike it.
These were really hard to understand, honestly, just like kind of the intent and how you're able to determine this information is seems complex. Okay. Moving on, next one I have here is immediate notice. And I actually don't know if this is necessarily a prompt to actually revise the definition itself or have a separate conversation about a separate requirement. But this term is at least used in the PIC change rules. I wanted to see if anyone had appetite to potentially revise a window for PIC changes. So giving immediate notice so that the board's up to date, they have their profiles updated, et cetera, but kind of allowing a 30-day or so window to potentially identify a new permanent or temporary PIC. Did a little bit of digging, and it seems like there's at least a few states that do 30. States like Florida, Nebraska, North Carolina, and Wyoming were ones that I had just picked out. I wasn't sure if anyone had thoughts on that.
Very few have immediate notice, and I would be supportive, being a former operator, overseeing lots of stores, of having some sort of grace period allowed. I obviously there needs to be somebody that's responsible for the pharmacy, but I do think that there is a value in having some time for somebody to find the right person. In the case of a termination or something like that for cause, there's no opportunity to really find somebody that is the right person necessarily, and post it and do all those kinds of things, and also give potentially external candidates the opportunity to be hired for jobs. So I feel like there is some value in at least having the conversation, and maybe that's a later conversation. But I do think Arizona is a little bit different than many states and the requirement for immediate notice.
I would agree with Lori. I think the way it is right now, particularly in organizations that are even moderately large, an organization with 2 or more stores, you end up third. I need to know order to find somebody. That's not entirely fair to the pharmacist who's the only one left standing to have to be PIC of 2 stores until you can find someone. So there's the ability to be reasonable, allow someone to find the right, or punish a person who's just filling the role because to check a box on our rule.
Yeah, like the PIC responsibilities still need to be taken by somebody in order to keep the pharmacy running. It's just, I guess, whose name is on the.
Well, no, I would argue that they don't. I would argue that, if the pharmacy is going to stay open, they will have a pharmacist present, but the organization should be given time to find a new PIC. To hold, say, a temporary staffing agency pharmacist accountable to be PIC, not having been there but an hour, doesn't seem reasonable. And it doesn't meet, and so the alternative would be then let's just shut down the pharmacy, and that doesn't meet patient care. So I think if 30 days is too long, maybe it's 10 days, but immediate seems to be unreasonable.
Well, and I think you're oftentimes going to get people that aren't probably best suited for the job sometimes, because you're making especially in the case of a for-cause termination, you have to do it without any notice at all. Even if you know you're going to do it, you can't replace somebody until they're gone.
And we've had scenarios like that, and we totally understand it. You haven't had a case before you that pertained to this immediate notice situation. Being a former operator myself, I definitely understand the challenge.
I think it's a worthwhile discussion. I think we just have to figure out, let's assume it's 30 days, who has the responsibility. It may be that there needs to be a notice of determination of the PIC, and the permittee has to accept that responsibility and identify at least the pharmacists who will be there. But you may want to put it in writing to just make that happen. But that may be a larger discussion at a different point here than this definitional discussion.
Without adding a lot of complexity to the definition, is there a risk of putting the 30 days like other states have?
I mean, in theory, we could strike the definition and amend the rule later. So that could be the recommendation here.
I think there's some other things that do have immediate notice, though, not just the PIC.
Oh, that could be true.
Yeah.
I think like a theft of controlled substances.
Which I do think should be immediate notice when you're, especially if you're talking about employee theft. Should it be within 24 hours or within one business day?
Good point.
Immediate notice, while I think it has a place, even notifying the board on something that has to do with narcotics, by the time you become aware in a health system, by the time you become aware, by the time you run the reports, by the time you get the right people on board to evaluate and understand what's going on, 24 hours can be gone very quickly.
I agree, and I think that brings up another conversation when we talk about controlled substance losses probably later with the 106 process. I don't think that the 10 business days is probably even sufficient, but if you know you caught somebody with pills in their pocket or they were impaired at work and you by video saw that they were taking medications off the shelf or something like that, I think that that should be an immediate type conversation. You may not be able to clarify the extent of the loss, but if you can clearly see that somebody was stealing controlled substances from a pharmacy, I do think that that is important that the board knows very quickly.
The times that I've had just clear cut theft has been the minority. Usually it's something much more complex and complicated that we've got to put some technician auditors on to super sleuth and figure out what happened. And it always
Which is why I think the 10 days is too short too. So is your suggestion 3 business days there, Cam, instead of 24 hours?
Yeah, I think that accounts for any HR issues of terminating somebody and any other sections that are impacted by immediate notice may be fair.
Is everybody okay with that?
Yes, and then we just have pick as
have we done a look for where it shows up?
Yeah, it's in quite a few places. It's under change in personnel and responsibility, so we could decide if we want to use it there. Under SIN statute, under
606 has it, immediate notice of change of PIC. 608 designated or terminating a pharmacy in charge.
I think it's all PIC change or PIC termination.
See, because I think you might want to have notice of someone being fired promptly. I understand that you may need to do time to get the replacement, but that person you may want the board to be aware of, particularly if the rationale is they were engaged in inappropriate conduct and things like that.
I agree, and that's kind of my point, Roger. I feel like there's something about notice, and then there's the replacement part of it. Like if to your point, if somebody was egregiously misfilling prescriptions and was terminated by an employer, the board should know about that. If they were impaired at work and were terminated for that reason, we would want the board to know about it very quickly.
The qualifier that you just said, impaired at work, that would be after that. The time frame would be after confirmation of such, right? Like if you potentially drug tested somebody and you then got the result. It's not upon the suspicion that you're thinking, right? Or is it just on the termination?
It's, according to 608, it says immediate notice of designating or terminating a pharmacist. So I think Mr. Pond was stating that, there's challenges of even terminating on simplest cases, but if you run into HR obstacles and stuff, you haven't terminated that person yet. I may have to rethink this 3 business day thing too, as well. I think the action of the deed is already done. You've already terminated a person.
I think that the challenge we've run into is the clarity around what it is we are reporting. And oftentimes these become more complex as soon as you start looking at some of the reports. And what we've done in the past, in some situations, has been reporting the minimal quantity that we are aware of, but we're discovering more. And it's just sometimes, I don't know, with a little bit more time, usually these are resolved in probably between 3 and 10 days on the diversion reporting. For other immediate notice, I think that 3 days is plenty, but.
And I think we're going to address the DA 106 situation and align it more with what the DEA requires is notification to them about something that took place and then amending it later on, which is totally allowed by DEA.
Yeah.
And I think from the pulse of the situation, I believe we're moving in that direction as well. But if you immediately terminate somebody for wrongdoing of some sort, it'd be best if we knew right away. I think 24 hours, the action is done, right? They're not going to say, hey, we're about to terminate somebody and then you got HR obstacles. We're asking that after the deed is done, you let us know. So 24 hours may be a reasonable time period for that purpose.
And then I couldn't recall if recalls have an immediate notice time period, if any recalls. And they may not.
I don't see that.
That's not it's not connected to immediate notice in our section.
So maybe
Okay.
we leave the definition of immediate notice the same or change it to 1 business day instead of 24 hours in case it occurs on a Sunday or something like that and somebody needs to run it by a legal department before they can do the notice. And then look at making a modification under 423-405, which is change in responsibility. And instead of saying, right now it says a pharmacist designated as a pharmacist in charge or establishment shall give immediate notice as defined. Maybe we look at changing, or maybe it's not even that. Maybe it's the assignment of the PIC in a different role. I don't know. Because to me, it's different if we're talking about just the notification of terminations versus the replacement.
Fully aligned. I think that makes total sense. They're different things.
And that's actually consistent with a number of other states that give you a grace period to find another person.
So this is Sandy. So let me be clear. You're looking to redefine immediate notice just for the notification of the pharmacist in charge?
You have to assign a new one.
I think this definition revision, it just clarifies 24 hours versus 1 business day for anywhere this term is used. Just to clean it up a little bit. I think the PIC change window is actual rule revision in the chapter.
Yeah, maybe under the facility requirement. So for example, under R423-610, where it says every pharmacy shall have a pharmacist in charge, and maybe we clarify how long they have to replace one.
Well, the reason I was asking about the immediate notice, because that terminology is used in statute in 1926. And it says pursuant to board rule, a pharmacist designated as the PIC for a permit shall give immediate notice to the board office of the initiation and termination of such responsibility. So that's why I was asking if that specific term was being redefined.
So the definition is actually only in rule.
And again, that statute says pursuant to board rule. So that's why I'm asking, are you changing the definition of immediate notice for that PIC initiation and termination?
I think the only change to the definition right now is 24 hours versus 1 business day.
All
I
right.
think
But
Danny's
we may,
correct.
but we may decide on a grace period for the assignment of a PIC at some point in time later.
And that would require a statutory modification as well. Sorry.
Okay, thank you.
So I'll take a note about that as well for legislative change.
Good to move on?
Yep.
All right. So next one is the immunizations training program. The actual rule that it references, I believe, talks about hold on. I think it talks about components of the program, and those components I think some of them are only in the pharmacist programs. So like, actual like clinical designation of the vaccine, like choosing if someone's eligible, I believe. So now if we pass the technician rule to allow the technicians to immunize permanently, then it just may need a little bit of tweaking as to how that program is specific to technicians for the administration portion. It could also just be a cleanup part that we do later. Yeah, so it talks about immunology, human immune response, and then the administration schedule, whereas I think the technician one just covers the administration portions that are in number 4 and 5 in R423, 411. Don't think it's a huge deal, just a little bit of cleanup. And it also says the training program for pharmacists or interns. There may need to be just a separate section in that same rule that just says the training program for technicians can be just similar to the above without the clinical portion.
I think in the language we submitted, it says a pharmacy technician complete practical training program that is approved by ACPE. This training program must include hands-on injection technique and the recognition and treatment of emergency reactions to vaccine.
Yep.
So that's basically what is the language we're working on right now.
Oh, okay. Well, I guess since it's in that section, it should be good then, because it's its own section. Okay. Ignore me.
Sounds good.
Next here is inactive ingredient is nowhere in the book. That absolute term. Neither is inert ingredient. I thought maybe they could have just used the wrong term.
I don't think it's probably necessary to define it.
It could also just be defined in like FDA or something.
I'm sure it's somewhere described in USP.
Yep. And that brings me to my next topic. So not an expert on sterile compounding, but I do believe that there is a pending revision to some of the compounding chapters of USP that will come out someday. I was wondering if it would just be helpful to the board to, instead of have to react and modify some of these definitions then, instead just calling things like the ISO class 5 or ISO class 7 as defined in USP. So the definition is just a little bit more flexible. Now, I did go in and they were in there. It talked about, you know, of course, the number of particles per volume or of air or something.
Are we able to reference that legally? I know some states can't. I don't know how Arizona falls to reference another external.
Yes, we can definitely reference a source.
I think it makes sense to just as defined by USP and not have the specific information, because I think that's going to continue to evolve over time. Mark, you're probably the closest to this space of any of us.
Mark?
We lose him.
All right, any concerns with that approach? I'm good with it.
Sounds good.
I would probably reference the official compendiums since that's your statute
Sure.
Reference.
All right, we'll make note.
Can you go back for 1 second to licensed healthcare professionals? And I think we just need to update it. If I'm looking, this list was accurate, but I think 15.1 is, chapter 15.1 is dispensing opticians, which I think also fits within here. And chapter 21, I believe, is veterinarians, which we don't have listed here. Now, maybe we don't need to include them, but I think we do, because I think they both have authority to write, and that's what these are relevant for.
That chapter, which one, Roger? I'm sorry.
15.1 is dispensing opticians, and chapter 21 is veterinarians.
Didn't we just reference ARS 32? Because isn't that all the healthcare professions?
It's got a bunch of others, though. It's got real estate and contractors and barbers.
Okay. I guess they can't prescribe.
Acupuncturists, private investigators.
Next one I have here is a low income subsidy. So that's also in the donation rules.
Drake.
And then next is materials approval unit, which I did not find anywhere.
I don't even know what that is. Is that with manufacturing?
I suspect that's where it originated.
Awesome. We have two more automation things up next. I think these are not defined as automated because they're a little bit lower tech than some of the prior devices. but from what I understand, I think the mechanical counting device for a drug in a solid oral dosage form is like something that just counts.
Yeah, like your Uyama or Parada or those kind of things, old Kirby Lesters.
You know what those are, Emily? Kirby Lester?
I do. So those are things that you just like pour things into and the pills come out immediately. The next one is ones that count and package, correct? So these are both used within a pharmacy.
Yes,
both,
these are-
both the
these are
pharmacy
in pharmacy
exit before it
devices.
leaves.
Okay. Okay, then I understand those. Does anyone else have questions about those? I was just validating. Okay, moving on in the interest of time. So this one I am not an expert on by any means either. But I was reading through this medical practitioner-patient relationship, and I've definitely seen that there has been some movement in telehealth, and I wasn't sure if these requirements needed changing in order to constitute an appropriate relationship between the patient now that new means, I believe, are allowed. Like, I believe like audio only, for instance, I feel like was one of the bills. Would that then require a physical exam?
I feel like I need to read that bill a little more closely.
Yeah, this is one that I definitely need legal help on. My read on the bill was very, very like, you know, it looked like things were changing, but I wasn't exactly sure how it would affect something like this.
I think it's one of the broadest telehealth bills. Roger, I don't know if you've got any thoughts on this anywhere in the country, so it probably does need to change.
Well, no, it does. And I think Governor Ducey described it as the broadest in the country when he signed it. But for example, the definition here says after they first conduct a physical exam. And since we have approved telehealth, that just isn't accurate. The exceptions in there were the old exceptions. We now have, you can do a full exam and prescribe with it over telehealth.
I think we'll also have to look at the DEA because I think they've made a couple of recent changes to their telehealth regulations as well.
Yep.
In the interest of time, just I want to ask is, do people want to continue with going through these definitions one by one?
I think it's been useful.
Yeah,
I think it's a good discussion.
Okay.
Yes.
Okay.
And if we run out of time today, I think we can continue it to another day. I don't know if we have a hard stop today or how everybody's schedule is. I know this is a little bit longer than some of the other meetings have gone. But I think we could always continue it. I think there's value in it.
Okay, I was just doing a gut check, so I'll just keep going and stop me when you want. So this was the counter thing. I think we decided that we're going to try and make these two definitions one, an all-encompassing definition of what a counter space should be. The immediate next definition is pharmacy law continuing education. We already decided to strike continuing education for pharmacy law. So this one, if we strike it, we'll also need to amend the rule to say that this is no longer a requirement, basically. So just removing like any reference to it in the rule.
I agree with that.
Okay. I think it's just an artifact of when it was required. Poverty level, another definition for the donations. And then, okay, so prepackaged drug is that exact term is not used.
Prepackaging is in 402. There's also a section in the hospital regulations, although that one needs edited because it says repackaged instead of prepackaged, which has been incorrect for all of these years.
So totally agree. I think the issue is that it's not used exactly as the term prepackaged drug from what I saw in 402. It says you could prepackage or supervise the prepackaging of drugs, but there's no such use of the term prepackaged drugs. Well, what may need to be defined is the term prepackage or prepackaging. I think it's technical.
I think it fits for what's under 402. I don't know about the hospital side.
We're into this with other states on prepackaged stuff that we could dispense out of the emergency room.
So I don't know, like, I'm not questioning the importance of like defining repackaging. It's more so that this is not the exact term used anywhere in the rule. There's prepackaged product, there's prepackaged, you can prepackage a drug, but just like the inclusive term of prepackaged drug isn't used. So it could just use a little bit of tweaking, maybe.
Okay, we'll look at it.
Okay.
Before you move past that page, Emily, where is proprietor used?
So I believe it is used. Hold on, because I did check that one. So it's in statute. Talking about the pharmacy owner's liability. And then also prescription records in statute. And then filling foreign prescriptions in statute. What's interesting is one, the definitions in rule, but all those references are in statute. And all of them are just like proprietor or PIC or like pharmacy manager. Could be responsible.
I don't know when you would use proprietor, when you could use permittee.
Is it an artifact of the way that the statute is written? Because all of these are in, to Emily's point, the statute.
Right.
I think it's an old term, but I don't think we can probably get rid of this. Or can
Well,
we?
maybe put this on the statute cleanup list part.
Yep, I added it, Roger. Thank you.
Okay.
I also have one thing under prep area. The second allows statement, I think there's a typo. It says allows personnel to don personnel. It should be personal.
I think you're right. Okay, red C stamp. So it basically the definition for this is just like defining how it's used, and how it's used is already in the rule, plus its height. So I think there's probably opportunity to condense this to just say red 1-inch C stamp in the rule instead of having a definition that says what it is. I think this is also in DEA too, right?
I think 2525 defines it for the prescription. This defines it for an invoice because the DEA requires invoices for Schedule 3 through 5s to be readily retrievable. And this was the definition they put in to accomplish that for an invoice.
Should this then say 3 through 5 in the definition?
It says an invoice of a Schedule 3 through, actually does say Schedule 4.
Is that still a requirement with the DEA?
I'm going to pull that up right now to see if it's 4 or 5.
I think I'm not sure about the 4 or 5 thing, but I thought it was an alternative of you could have the red C stamp as a way to make it retrievable, understanding that electronic records are not going to be physically stamped. There's no way to do that. Unless you could do that on whatever that device is called.
Microfiche.
No, that's just for viewing.
Do you know what a slide is?
Yes, I know what a slide is.
Okay. It's almost like a slide, but it's like a big one.
Okay, got it.
I'm sorry, this is Michelle. I'm going to have to jump off to join another call, but I will come back when that one's done.
Bye, Michelle.
Bye.
Cam, I think we've lost a couple of other people procedurally. Do we need to check to see if we have a quorum, or does it matter with the task force? It's appointed by the board.
It does matter. I think we still have a quorum. Let me double check here real quick. Yeah, we still have a quorum, so it's not a concern.
Something I noticed is R423612 does have this, it does say that it's required for C3 through 5. So I think that's what you're talking about for the invoices, because the C2s need to be stored separately.
Right, they always need to be stored. Yeah, it is 3 through. It looks like they did make a typo. It is 3 through 5.
And then there's also a waiver in the DEA's rule too, with some of the electronic documentation, it looks like. However, if a pharmacy employs a computer application for prescriptions that permits identification by prescription number and retrieval of original documentation by prescriber name, patient's name, drug dispense, and date filed, then the requirement to mark the hard copy prescription with a red C stamp is waived. I don't know if that applies for.
Yeah, that's the
invoices.
prescription component.
Yeah.
I think most people probably just store them separately, and that's probably why we don't even really like understand.
Actually, no, and I have issued violations for improper filing of Schedule 3 through 5s and non-controls mixed together without being readily retrievable.
Okay, good to know. Then maybe this is all it needs, is just the 5 updated from 4. What about the DEA exemption though?
That's for hard copies, not for invoices.
Okay.
I don't see it in there for invoices.
Any other, moving on to responsible person? I think my guess here is that this is an old version of designated person. Yeah, what is it?
Designated
Representative?
representative, yeah.
Yeah. It's not
We have
used
that definition elsewhere, designated representative then.
not in the rules. Hold on.
It's not a statute either.
It's talked about.
Yes.
So do we need to substitute those since that's not really the, or does it matter?
All of the statutes that I'm seeing say what the designated representative has to have. And who has to have a designated representative. The designated representative of a wholesaler needs to be 21, employed, blah, 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 physically present, not have any criminal convictions, etc.
I think that makes sense.
Okay. Security features, yeah, I didn't see this either. Or actually, it's in statute
Yeah.
only.
The statute references security feature, but it doesn't define it. That's why this was placed into rule.
Is that defined by DEA or is it just like a guidance that they give you on what could be an acceptable one?
Well, that particular section, let me pull it up here. That particular section for the security feature is not for a controlled substance. It's actually for a prescription that's generated with electronic or manual signature, generally electronic, I would say, and then handed to the patient to walk into the pharmacy. So it's actually a non-controlled medication that it addresses. It's the only security feature component that we have for any of our types of prescriptions.
Like the heat or something like that?
Yeah, and the statute is 1968, A4.
Sounds like we should keep it then, is that what you're saying?
I think so, because otherwise we don't have a definition. Since they didn't define it in statute when they added it.
Okay. Moving on, any additional that you want to grab? There's all the shared services ones here. Okay, site readable will need to be modified to just remove the term CRT.
But Emily, what if I still have a CRT? I needed to see my microfiche.
And
display.
microphone.
It could either be removed or maybe replaced with the word display. Next is the single drug audit, like we said, is not in the book, but the following term is the updated term, single drug usage report, and that is used. So we're just going to go with that. I think is what we said before.
I agree with that.
Okay.
State of emergency, anything we need to do there since we've been in that for the last over a year and a half?
So it is specific to a natural disaster or terrorist attack.
Or you have to add the word pandemic or something to it.
Or other like disaster.
How about public health emergency? Government declaration issued under ARS 3219 as a result of a natural disaster, terrorist attack, or public health emergency that results.
And would we have to get 1910 revised?
Yeah, we do. Can we just generically state it? State of emergency means a governmental declaration issued as a result. It's declared by the government, either state or federal, period.
Just stop after the ARS reference.
Yeah, I don't think we need anything else. I mean, if the government, state government or federal government declares it, I think we are in a state of emergency. Doesn't matter what kind of emergency.
Agreed.
Go.
Just making sure that it's broad since we've learned a lot in the last 18 months, probably.
Very true. There was one in here, substantial risk sterile pharmaceutical. Again, not a sterile compounder. I don't feel like I've heard that term before. I feel like I've heard low, medium, high risk. I wasn't sure if there's a reason that that specific term was used. I figured I'd just ask.
Because our compounding regulations were not drafted specific to the compendium, so it has different terminology. And those sections will hopefully be revised once we get a finalized changes to 795 and 797.
Okay, great. Just figured I would ask just in case. Next thing I have. Okay.
Clarify on supervision that the pharmacist is present in person or virtually? Just what we've now learned.
Yeah, because probably not a bad idea, Roger, because a pharmacist could supervise the work of a technician remotely in a telepharmacy, or even like the checking of data entry and things like that from a remote site location if the person was working at home. Direct oversight.
I have one other one here. Where in the world do we use the word tourist?
I think that's
up. It was up in the definition of what a resident was.
Yes.
Also.
I'm going back to the
Is that the-
supervision component because your Article 6 for your community pharmacies would not allow anyone in a pharmacy unless that pharmacist is present. So you do have work from home as part of the shared services component in 621. And you do have your remotes, which allows a pharmacist via all of those requirements. But you still do have sites in which a pharmacist being present is required.
True.
I agree with that. I just wasn't sure that supervision needed to require the in-person. You clearly have sites where pharmacists have to be there.
Yeah,
So-
and I'm kind of, oh, go ahead.
No, I was just gonna say present is virtually or in person. That's just agreeing with Roger, what he said.
I think in the community pharmacy aspect, is there a situation in which the individual providing supervision is not the same individual that is observing drug control? The person on site is probably responsible for drug control, right? But are there situations in which a virtual pharmacist may be validating the PV1 of an on-site technician and providing their supervision? I'm not sure.
For a community pharmacy to open, a pharmacist has to be physically present.
Yes.
That doesn't mean that they can't have a shared service component of data entry or, things
Processing.
of that nature, counseling and well, I don't know that I'd go to the counseling component, but anyway, but it would be the pharmacist on site that would be responsible for the supervision of the licensees and other employees within that pharmacy space at that time it's opened.
Does there
Okay,
have
yeah.
to be somebody on site though?
For a community pharmacy, yes.
I think operating a community pharmacy is different than supervising people who perform in a community pharmacy. I'm fine with having a community pharmacy in order to operate, must have a pharmacist physically in the pharmacy. But I think lots of stuff can be done and supervised outside of that pharmacy by other pharmacists.
Like they may obtain direction from an offsite pharmacist.
I think almost all PV1 could be supervised remotely. And if it's a bigger discussion, it's fine. I saw the word supervision and thought we might be able to do it there.
Yeah, I'm wondering if it's like, if there's already something that says in the community rules that there needs to be the pharmacist on site, this wouldn't supersede that. Let me check. Or maybe it's just confusing if it is a shared services aspect and that's already allowed.
Or do we need to define direct versus indirect supervision?
If we just eliminate the word direct.
This may be something where we could use another state too. Like I feel like I've seen words like awareness, direct charge, oversight.
On some states allow for a technician to be present in a pharmacy during like a pharmacist meal break, for example. And the
Oh,
technician can't do like sell products that aren't obviously already verified by a pharmacist, but allowing patients to continue to drop off prescriptions and the process to continue and those kinds of things as well. I don't think we would have to make a lot of modifications to allow that, but might afford additional opportunities for pharmacies to offer meal breaks to pharmacists too. But that's a whole separate rabbit hole.
Ooh, Roger, you're on mute.
Why, I don't know if we were done with that one. If we were, why do we need supplying?
I don't know.
How many different meanings do you have, Roger, as far as supplying goes?
What? I just don't know why we need it.
I mean, it's used several times, I guess, and
Yeah.
But again, I mean, how many different meanings do supplying have? You'd be the one arguing that point, Roger. That's why I'm asking.
Well, I mean, supplying, it's moving from one person to another. I don't know, if we think because it's used in the regs elsewhere, the statute, we need it for context, that's fine. Just seems strange.
It is used, but it's also used in the same context that it's spelled out in definition.
So are you
I'm
recommending
sorry.
keeping it, Cam?
I'll revisit it. I'll take a look at it. But I mean, if it's saying the same thing, for instance, I believe I've read a section where it says a non-prescription drug in the manufacturer's original container. It's reciting essentially the same thing that it is in the definition. So I don't understand why it's regurgitated.
Take a look, Cam. See, if you don't need it, let's get rid of it. If you think we need it, I'm happy to deal with it. I think it's superfluous for where it is.
Another donation one.
Roger, to your point about the tourist, do we need a definition of a tourist? What's the purpose of it? I mean, it's the PC term for a snowbird, I think, but
Good point.
Did they get a discount on their licensure renewal or?
there's two places that I see it. It's in the definition of tourist and then in the definition of a resident. But I don't see it anywhere in rule or statute.
The resident might actually be the donation in the donation rules. It is very confusing actually. If you just control F resident, it's just nonstop citations to resident and non-resident pharmacies. So it's a little bit hard to dig up where like the reference to a person is.
If we need it, that's fine. It's just funny.
I don't know why why we need residents either.
It's probably one of those things that I wonder about a lot. There must be a story. Like 60 years ago, this was absolutely necessary for some purpose. It's like the part of our code that requires us to receive a fax from a patient, but we can't fill from it. The story behind that statute comes from Rick Murphy, a representative who was trying to get some prescriptions filled. He knew that he was going to be at the pharmacy late, said to the pharmacist, I have some prescriptions in my hand. I'm going to drop my family off. I don't want to be that guy that hands you 5 prescriptions with 10 minutes to close. Can I fax them to you? I'll bring the hard copies with me. And the pharmacist said, no, that's illegal. And he says, it's illegal? Well, I can do something about that. He made a law. It says we got to be able to take a prescription from a patient, but we can't fill from it. I bet you there's a story behind the tourist. That was a really long, tangent.
I think I honestly think it might be in the definition, in the donation rules only, because saying that like only residents or something are able to get them. Oh, actually, no, there's also in the non-resident permits, a person that is not a resident of Arizona. We get to move on.
Yes.
Okay. Our unearned income, just like all the other donation stuff, strike is I think what everyone decided.
Agreed. Now throw up my next one. Veteran. Why do we have veteran defined? Nice.
This is for the licensing, I think. For the like spouse thing. Is it? Maybe I'm
Isn't
thinking
there
of
a
the wrong-
discounted license for veterans?
Oh, and it's actually in the donation too. Oh my gosh.
But I don't know. Kind of seems obvious.
Oh, never mind about the licensing. I think I was thinking of another state.
If it's only in the donation, then we can pull it.
No, it's in eligibility requirements. I'm sorry, it is donated section. There's about 7 places it's used.
It's in statute.
Yeah.
Talks about the VA. Okay. Almost there. We already talked about verified signature or signature verifying could probably use amending.
Working, yeah.
Yeah. Just clarifying the signature requirements. So that gets through that big chunk. And then I think it's just the hospital definition. So under, unless anyone has any others. Okay, hospital definitions are under R423-651. The term dispensing for hospital inpatients is not used in the book. That exact term, kind of similar to the pre-packaged drug terminology.
Come on in.
Who was that talking?
I think
Missed that.
Roger.
I'm fine. Keep going.
I think from reading that definition, if you look at the bottom, it says herein referred to as dispensing. I'd have to literally go through all of those hospital sections, but I would suspect that they're referencing, rather than saying dispensing for hospital inpatients all throughout those rule sections, they changed it to just read dispensing.
Okay, that makes sense. No action needed then. Thank you. Then floor stock isn't used.
No, I think that's one of those old terms as well.
And then this is the one, Sandy, that you were talking about as well. And I'm not quite sure what you said, if it's supposed to be prepackaged, but I'll let you explain this one. The
Yeah,
repackaged.
it should be changed to prepackaged since it's packaging by a pharmacy, not a manufacturer.
And that is all I had for definitions. There actually is a supervision definition in here too, which is separate. I don't know if we revisit that other one, if they're somehow like not combined, but similar. And that's it. Any other thoughts or questions on these definitions?
Cam, my questions to you in the past about satellite pharmacies on hospitals, does that definition hold, and we need to go about that a different way?
You mean whether they have to be on a campus, and are you more pertaining? Well, we do have that remote in this year's bill. We are addressing your concern, I think, about adding remote hospital pharmacies to like those ED mini clinics or mini hospitals and stuff like that.
Okay,
So we're addressing it through that process.
thank you.
I think staff had some additional definitions below mine. Or yeah, we could do this.
Well, I have a quick question. Where it's crossed out under a remote dispensing site pharmacy in the, I don't know how to explain where this is at because I don't have the numbered, but in the amendments or the edits, it has it crossed out in red. I guess I don't understand why this was crossed out under remote dispensing site pharmacy. And it's what you just referenced about the remote hospital site pharmacy.
It's not in a section that we just talked about, is it?
No, it's in that bill, the 1087. Page 9. A remote dispensing. So why is all of that crossed out?
You know, that I couldn't answer for you because I didn't cross that out. I'll look into it.
From what I thought, just compounding was going to be taken out of that, maybe. But the rest of it looked like it was correct.
I'll look at it. I don't know.
Okay.
Roger, just to let you know, on a lot of those terms that you are talking about, tourist and so forth, in the definition section, a lot of those were added in when the donation rules were added in 2008.
Good, so then we can probably take them out then.
Yeah, it looks like they added earned income, family unit. low income subsidy, Medicare, poverty level, all of those things came about from that donation rule change in 2008.
That's really helpful. Do we want to do this chapter here up on the screen?
How's everybody doing for time? Are we okay?
I don't have conflicts.
I'm good
Keep
as
going.
well. Okay.
I have another half hour max for me.
Okay.
I do have to leave.
Matt, you need to leave now.
At 3:30 I do.
Okay. So it looks like we're getting to the point where we're losing quite a few.
I have to leave at 3:30 also in 10 minutes.
Okay.
Okay.
Do you think we can get this done in 10 minutes? I don't know. Or
I
is
could
there
try.
another section that maybe wouldn't take as long?
I think the other section would be reviewing our draft language, and that may take some time.
Okay.
I
I
don't
can.
think-
Okay.
I can reschedule this early part of July, right after 4th of July, if you'd like. I did confirm with Jean that, because this meeting is taking quite longer than I anticipated. We're not obligated to finish the agenda, but I can reschedule it if you'd like.
I think that would probably be good because I think we're going to lose some key people here, just out of respect for the group, to make sure we get enough input. That's my personal opinion, but I'm able to stay on too, so either way is fine with me.
All right, I was looking through the section where I modified some stuff. It gets a little messy. I could have done a better job cleaning it up. It may be best if we do meet early part of July so I can have a better non-repetitive draft for you. Because some of it does repeat over and over. So it's your
We
call.
call it. We call it. I think this will take longer than 7 minutes.
It is going to take longer than 7 minutes.
Yeah.
All right, let's do that then. And do we want to look at a time now? How does people's schedules look the week of July 5th? Obviously the 5th is the holiday, but how's everybody's schedule? Or do we want to just do a doodle poll for Cam?
I can send out a doodle. That's not a problem.
Okay. Let's do that then. All right.
Thank you,
Sounds
guys.
good. Appreciate everybody's time. We will, I guess, adjourn the meeting for now and reconvene with the rest of the matters the long week, the week of the 6th.
Right. Sounds good.
Appreciate everybody. Thank you for the
Good
good
job.
discussion.
Thank you, guys.
Aye.
Thank you.